Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case.
Dati mihi Anglican boy,
Because he's the guy.
All right. Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. I'm very blurry, too. It's a good thing you can't see me right now. Oh, there we are. Now I'm worse. There we go. Good morning. It is great to be here. Happy Tuesday morning. Just 2 more days till the podcast. Oh, man. I just got back from the post office. Paula Mac. Thank you, Paula Mac. I got an emotional support pickle from Paula Mac this morning. Thank you very much for that. He's going to join my posse. I have a posse of emotional support pickles. I'll have to set it up. It's going to be awesome. Yes, this one has a scarf, like a red scarf, and I have not seen one like this before. It looks awesome. I haven't opened him yet, but I need to. I just barely got back. But Paula Mac, thank you very much. Thank you. All right. So I can't believe she decided. Wait. Before we do that, wait. We have a brand new. I think we have a first time offender. CW. Welcome. First of all, hello. Good morning. Thanks for being here. Not sure if you know this, but being the first in chat isn't always a good thing. I mean, it's rarely a good thing for the person who was first in chat. We realize you're excited to be here and excited to talk and say hi to everybody, but it was quiet before you did that. It was peaceful, and you broke that silence, and so we're going to punish you. I apologize. Ignorance is no excuse. We're punishing you for your promptness this morning. We're going to send it to you to internet ownership, and you're responsible for everything IP related worldwide. You're responsible for keeping it up and running. So chat not on screen. I'll fix that right now. There we go. Boom. Chat on screen. Oh, I can do it here too. My buttons are working. I fixed the buttons. I'm so excited about this. It's just a networking issue, but let's see. The contest winner. We had the contest winner last night. Congratulations, CW, by the way. We had the contest winner last night for the buttons. And I sent off the gift. I hope it got there. If we could get a little confirmation in chat that it arrived. I'm not sure if he's here this morning. Let me see. Go into the burner phone, see if we got a response.
Have them send someone with more experience.
Amber, we have a suggestion as well. If you take all the guesses, and I think because we had guesses in the millions, we might have to remove the outliers. But if we take all the guesses and average them out, how close were they to the win? Let's see. Hang on one sec. Bob Roberts. I happen to know Bob Roberts' real name. This is his internet name. So, Bob Roberts, are you here? I've been texting him. I can text him directly. But a gift was sent his direction. Let's put it that way. There it is, Bob. Did it arrive? Did it arrive? hopefully it arrived. Otherwise, I sent it to the wrong person. So, all right. There might have been a donka in there, which I think means thank you. Thank you. All right. We're going to start court in a while. It might actually start. Bob got it. Yes, that's the good news. Because if you said didn't get it, I'd have to send it again, which might have been good for you. But somebody else out there was like, there was a button contest, and I got this. Did I enter? But I'm glad. I'm glad you got it. That is awesome. The correct answer was 1,154 buttons. Bob guessed one extra button, and he told me he counted this one. So paid very close attention. This one did not count, so he was one over. But wow, attention to detail. This was not a guess. This was a calculated. I'm sure many minutes were spent paused in front of the big screen, counting and researching and doing all that. So Bob, congratulations! It paid off in a big way. So congratulations. That was a lot of fun. Congratulations to everyone who entered, and it was a lot of fun for Amber. She says she told me maybe in her sleep last night when she butt dialed me that she wants to do more contests like this and more complex ones as well. So, or maybe I dreamed that, Amber. I'm not sure. She's going to be like, quit. All right. We have birthdays. I'm sorry, I missed the birthdays here. Thank you, Sharon, for the reminder. We're going to bring up the birthdays. We have Jill and how do I pronounce that last name? Can somebody help me? Is it just like it sounds? Is it like when two vowels go walking, the first one does the talking? And the phone extraction report I ran just proves that didn't happen. Let's see. The second name pronounced, is it Jape or Jop or Jap or Jahip or Yap? Is it a Y sound? I'm confused. I don't know the name. Somebody help me here before we sing.
Happy birthday. You look good.
Judge, thank you for chiming in. Somebody help me with the pronunciation. I'm getting zero help in chat. Zero help. How do I pronounce this name right there? I've got this one down. This one right here. Sorry, that's all of them. This one I can do. I'm confident in my pronunciation. This one I'm not sure. I can't sing until I like gap. It's pronounced G like gap or J like jop. Should we do jop? Somebody out there whose name this is, who they submitted, knows for sure how this is pronounced, but we're going to say jop. Let's say jop. Here we go. All right. It's time for the birthday song. What do we need? What that means is J like Jeep, but app like gap. So just Jap. So Amber. Okay. Jap it is. All right. What this means is everyone needs to stand up. It's Dutch. It's Jop. Okay. Now, Amber, you and Red Pen disagree, and I hate to throw you under the bus like this, but I trust Red Pen's pronunciation guide. She has never, ever led me astray. As a matter of fact, she corrects me many, many times. It's Yop. Yop, yop, yop. Okay. Or Yappe. Samantha. Oh, wait. Alan Alda is 89 today. So we're going to add Alan to this as well. We'll add Alan. All right. Everyone needs to stand up. Take a deep breath. Pull your shoulders back. Project your voice to the back of the room. Blend your voice with the neighbors. Warm up with me if you will. La, 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 la. Excellent. Happy birthday to you. Happy birthday to you. Happy birthday, Jill, Yop, and Alan. Happy birthday to you. Jill, Yop, and Alan, happy birthday. Thank you very much. I realize there are a million places you could be, a million people you could be with, but you've chosen to be here with us. The privilege, the pleasure, the honor is ours. Hopefully we can turn that to you and make your day a little more special. Or help yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, and Andy's Grill, who I just drove by this morning. They're open. I think they're serving pancakes. I'm not sure if we have time to wait for the drum solo. I can tell you why, but it's because the judge just showed up, and he's early, which means we have to play catch up by a couple seconds. Man. All right, happy birthdays. Thank you. Everyone saying wonderfully. It was beautiful. I appreciate it. Looking for my... we've got that. So we need the counter in the corner. I'm trying to get everything ready, so as soon as the drum solo is done, we're going to jump to court. In court yesterday, the defense announced basically they're going to rest, that they're done, that she is not going to take the stand. Natalie is not going to testify in her own defense. Happy birthday, Nathan! Nathan's 25 today. We can do this one. Ready? Happy birthday to you. Happy birthday to you. Happy birthday, dear Nathan. Happy birthday to you. Isn't it 25 where you can rent a car? I think it's 25. Here comes the drum solo. Beautiful. All right. Green-Eyed Cat upgraded to jury member. Thank you, Green-Eyed Cat, for that. Appreciate that. And get cheaper auto insurance. Yeah, all those youthful tickets fall off at that time. Okay, we're going to play speed time and a half. Well, 1.5 speed for just a moment while we transition back to court and get caught up. Objection counter is at 118. Which is wonderful. That's plenty, and so we're like a minute or two behind.
The court calls the case of State of West Virginia versus Natalie P. Cochran. We continue in the trial. The case number is 23-F-343K. All parties are present.
The jury's not here.
Defendant, although we are missing Ms. Acord. Is she going to join us?
She will be joining us. She is at the office, but she's working on some stuff, and she'll be here.
All right. Thank you.
But I have her permission to go over the court's instructions on behalf of the prosecutor's office.
All right, thank you. I do have the individual submissions from the state and from the defense. I've prepared a continuous charge to the jury that incorporates all of the submissions, both from the state and the defense, and sets it forth in the court's traditional charge. I suggest that maybe we could go through that page by page. Again, I've mixed up your offerings a little bit, but all of them should be included in the mix. So you have a copy there of the proposed court charge. Yes, sir. All right, let's go through it page by page and raise any concerns that you have. Is there any problem with page 1?
Nothing to say, Your Honor. Thank you.
No, Your Honor. All right,
that's a good
page
start.
2.
That's a good start.
Nothing to say. Okay. No, Your Honor.
Page 3.
Nothing from the state. No, Your Honor.
Page 4.
Also nothing from the state. No, Your Honor.
Page 5.
Nothing from the state. No, Your Honor.
Page 6.
Nothing from the state.
Page 7, and you'll note that I put in the squib about expert testimony.
Squib?
Yeah, and in the paragraph after that, Your Honor, there's some gender change that needs to be made, I believe.
Okay.
Well, Your Honor.
Yes.
I believe Mr. Victor has a comment or objection.
All right, let me handle this.
Mr. Victor.
Is no paragraph on the defendant's testimony or lack thereof, Your Honor. It has to be.
Well, I do. I think I have that, but it's toward the last. I can move it.
Okay.
I'll find it.
Well, I'm probably looking.
I believe I did see that, Your Honor, but I can't locate it right offhand.
Well, everything gets lost.
I love this speed. I wish we could say this speed throughout the day.
Oh, it's page 12, and it's the second paragraph that starts with, as a defendant is presumed innocent of the charges brought against her.
I bought 3 more cables yesterday. Have to confess.
And we'll get to that.
Okay. All right, let's go back to page 7 and see if there are any issues or objections to any of the material on page 7.
Your Honor, the last paragraph. May I remain seated so I
Certainly, yes.
I believe that the offense charged in the indictment is murder in the first degree. The jury may return, I believe, 3 verdicts here rather than 2 because they can return the verdict of murder in the first degree.
Murder?
Guilty of involuntary manslaughter or not guilty.
Okay, we need to think about how to word this because the jury will be confused. We've never raised the issue of involuntary manslaughter with them, and to just pop this on them may cause
he wants
some
a lesser included
confusion.
Oh, he's drinking out of 2 cups too.
Any suggestions, Mr. Truman?
The state does concur that the language of the first paragraph of number 7 should likely be changed. And it may be just as...
Could we put one of the offenses charged in the indictment as murder of the first degree?
Yeah, that would work.
How's that, Mr. Victor?
But what is charged in the indictment is really murder.
Well, that's true.
Your Honor, may I suggest?
Yeah.
As number 3, or the lesser included offense of involuntary manslaughter.
See, the way that we have it is actually correct because it says the offense charged in the indictment in this case is murder of the first degree. That's right. You may return one of 2 verdicts under the indictment.
Okay, all right, I stand corrected.
So we're okay with it.
Right, but there has to be nevertheless recognition of...
Yeah, and it's right after that on page 8.
Bob.
No, I'm sorry, not 8.
Returns the gift in memberships for other people. Oh my goodness, Bob, that is awesome. That is super generous.
Page 10.
Thank you
Your
so
Honor,
much.
I'm sure Mr. Victor will volunteer some information. At the bottom of page 10, you say, you're talking about a distinguishing feature between voluntary and involuntary manslaughter. Voluntary manslaughter is not a consideration.
Right. I think we need to remove that. That somebody submitted that, and I guess it was either you or Mr. Victor.
No, I don't think we're there yet, Judge. I'm looking at page 8, and page 8 starts with murder of the first degree. And by the way, I don't know, this is a very, very minor thing, but I think we should be consistent with capitalizing certain things.
Okay. I think that's a big deal.
That's just,
Okay.
suggestion. But before, murder in the first degree is any felonious, willful, malicious, deliberate, unlawful. It has to be unpremeditated. The premeditation is the most important factor of the murder in the first degree. So it has to be there.
Okay.
And I don't know if we need to put the West Virginia Code section there for the jury.
All right, I'll remove that.
And then, of course, in that instruction, before the paragraph starting with before the defendant can be convicted of murder in the first degree. Paragraph 4, feloniously, willfully, maliciously, deliberately, unlawfully, and premeditatedly.
Okay.
And then, I believe, Your Honor, that at the end of page 8, we probably need to go and describe what is now on page 10, and that is murder of the first degree consists of an intentional, deliberate, and premeditated killing. And that definition is the definition of premeditation. Because otherwise we're going straight to malice, and we're discussing malice, and then we're going back to murder in the first degree.
Okay, so we just need to move that before we discuss malice.
I would so ask. Then, and I think that in that paragraph on page 10, describing premeditation, in the 3rd line, well, it starts with the duration of that period. I would say that this is the this should read the duration of premeditation, or of the period of premeditation cannot be arbitrarily fixed, and that's under Guthrie.
Okay. Any problems, Mr. Truman?
No.
Now, this is what I have. The duration of that period of premeditation cannot be arbitrarily fixed.
Yes, Your Honor.
Then I'm going to move this entire paragraph to the top of page 9 before malice.
Yes, Your Honor. Now, And then, since we're describing the offenses which the jury can consider, I would also move involuntary manslaughter definition prior to the definition of malice, because we've already talked about the definition of the first-degree murder. So now I think the next logical thing is to discuss the involuntary manslaughter, and then discuss the definitions of malice, and just about it.
Okay, where do you want to move that to now, Mr. Victor?
Before the top of page 9, before malice.
Okay.
Involuntary manslaughter is committed when a person caused the unintentional death of another person. Now, in in that paragraph, I think we have to modify this paragraph because, as Mr. Selden astutely noticed, this paragraph deals also with voluntary manslaughter, and we don't have any voluntary manslaughter anywhere. So I would propose the court instructs the jury that the absence of an intention to kill or to commit any unlawful act which might reasonably produce death or great bodily harm is either the main characteristic or the main feature of involuntary manslaughter.
Okay, if you can write that down, you talk a lot faster than I can.
Oh, I'm sorry, Your Honor.
That's okay.
I'm sorry.
Talk faster than I can hear.
I mean, I'll work it out the way you want it, but you'll need to write it down.
I think that the okay, I have it. The main component. Okay.
Involuntary manslaughter. A distinguishing feature between.
Okay, main components. And then, Your Honor, we're arriving at the definition of malice. I've been doing some research on malice, and in the first paragraph of malice that is right now on page 9, the last full sentence, malice and intent can also be inferred from the defendant's intentional use of a deadly weapon under circumstances which doesn't give rise to legal excuse. I believe this may have been this may be one of those instructions that shifts the burden of proof to the defendant.
What?
Although I believe that there's the State versus Jenkins case, and it's probably all right, but I
think this is a pattern instruction.
Yeah.
I've seen it many times. I don't know where Mr. Truman dug it up, but maybe right out of a form book.
I think it's just one of those stock instructions that the state keeps, and it's been offered as long as I can remember. If it needs to be changed, then let's hear what
we can change it.
I think inference is all right, but then in the next sentence, implied, and once the jury starts.
Okay, in the next sentence where it says it may be inferred or implied, what if we get rid of or implied?
Yes.
That's in there twice, so in the next sentence, get rid of it.
I see it up in the first paragraph too. Can we change implied to inferred?
Yes, Your Honor.
Okay.
Now, when we talk about involuntary manslaughter, I think that a full definition of involuntary manslaughter should be probably given, and that is, I will read it, and maybe I'll read it quickly, and then we'll try to parse it. A person is guilty of involuntary manslaughter when a result of the doing of an unlawful act in a reckless or grossly negligent manner, or the doing of a lawful act in a reckless or grossly negligent manner, he causes the death of another person.
Okay.
Was that in an instruction the defense
That wasn't
submitted?
an instruction.
No, that's
Oh, you're adding this.
right. I think that would be the appropriate definition of involuntary manslaughter.
Well, do we have that in writing? Can you submit that?
I can write it in here and present it to you.
Okay.
They were supposed to do that
Does that
already.
sound all right with you, Mr. Truman?
Yeah, I'd like to see what it
Okay.
Okay,
what it
let's
says
write.
before I comment on
Normally,
it.
there are written submissions that the court considers. Okay, we're okay with the elements of involuntary manslaughter.
Yes, Your Honor. I'll write it down and submit it
Okay.
to Mr. Truman. Now,
You know what it says to me? It says to me the defense thinks they're going to get she's getting convicted. Why else would they include involuntary manslaughter, which I think is a shoo-in for a jury?
Are we down to page 12?
They want a compromise verdict because they think
can we
they're
go
gonna
back
lose.
to page 10? And the
Sure.
only reason the state is always paranoid about submitting the Wyatt instruction about knowingly,
Yeah.
which is one of the dumber opinions to ever come out of Charleston. But aside from editorializing, I don't know if we need that paragraph. It's really not an element of first-degree murder.
Tell us how you really feel.
that's fine.
One of the dumbest opinions to ever come out of Charleston.
I mean, it doesn't necessarily hurt anything, but
You're talking about paragraph 2 on page 10.
a person acts knowingly.
You want to remove it in its entirety.
I'm just raising the issue because it's not an element. I think it's been offered in every case since Wyatt was decided. But it's there. I thought I'd raise the issue.
That's fine.
Can we just omit it?
We can remove it, sure.
Okay.
Now, on page 12, the first paragraph, that instruction is always questionable to me because this one, I believe, shifts the burden of proof to the defense. That
Even the client.
Okay, I don't know that we need it. If we take this out, Mr. Truman, will it be a strong objection?
A vociferous, okay, go ahead and take it out.
Okay, I'm going to remove it.
Vociferous, okay.
Although we do not accept the argument that it shifts the burden. I don't think it does.
Well, I've put it in virtually every
I know.
every charge that I've given, but I don't know that we absolutely
That's
need
fine.
it. Okay.
And once, since I stand corrected about the defendant testifying or not testifying instruction, which is on page 12, I always insisted on the word must, and that is 1, 2, 3, 4, 5, 6. Seventh line in the first, in the paragraph that starts with, as a defendant is presumed innocent. It says that you should disregard it, no, not it,
Yeah.
and not discuss it.
Okay.
I think it should read you must entirely disregard
Okay.
it because it's
Any problems, Mr. Truman?
None.
You
Mr. Truman's
must
a pushover.
entirely disregard it and not discuss it.
that's right.
How's that?
That's fine, Your Honor.
All right.
Anything else on page 12?
I think there might be in the next paragraph, second line. I think that wither is supposed to be weather.
Well, it was whether it just.
Okay.
Okay, I'll change
Defense is
wither
getting a
to
couple
weather.
wins
How's
in.
that?
We don't know exactly
Sounds
what
like a
they're
plan.
eliminating because
And
the
I
state
don't
surrenders
have any
without a
other
fight.
objections to the end of the document.
Okay. Page 13.
No, Your Honor.
Any problems, Mr. Truman?
This is getting kind of repetitive. Other than margin issues.
Well, we
page
can't do
13.
anything about that because that results from the way it was submitted.
Oh.
We tried,
Oh, okay.
but
You
it's
couldn't adjust the margins?
We're just going to have to live with it.
Okay.
This is terrible.
Anything on 14?
Second full paragraph is a gender issue, second line.
Are we on 14?
I think we're in real time now.
Second paragraph.
We were like 2 minutes behind this
you
morning,
had to
but I
believe
think we're
that the
caught up.
defendant.
Oh, I see it. Okay. Change him to her.
Right. And then the last line, committed the crime. I don't think it's an of that you need there. That just needs to be deleted.
No, committed the crime of. I think that's correct. The way it's. Judge, leave it in.
Run that by me again.
Yes, sir. The last line on page 14.
Yeah.
To establish the defendant committed the crime, I don't think of needs to be in there.
Right.
Oh. Okay.
It's always been in there.
Page 15.
She's charged with the crime of murder. It's not with crime murder.
Nothing from the state, Your Honor.
Okay. Page 16.
He committed the of
I
crime.
think it's the bottom, the last paragraph in that, the law presumes, that's all covered on page 2 of the charge.
I agree, Your Honor, and
Okay.
I think that if we need to have it, it can be moved to the beginning of the instructions, but I don't.
Yeah, which it's on page 2.
Right.
Okay. I propose to take out the entire paragraph at the bottom of page 16, and it runs through the top of page 17. Is that okay?
Yes.
That's fine, Your Honor, yeah.
Everything's getting deleted. We're good with this.
And likewise, on page 17, since we're there, the last paragraph is also covered on page 1 of the charge about the indictment.
I agree.
Now, where is it?
The last paragraph on page 17
Sorry, Knight.
is also
okay.
the
I'm
first.
going to remove
Yes.
the last paragraph on page 17, which runs one line on the top of page 18.
Court appointed. Which means all the experts were paid for by the taxpayer.
Okay, now page 18.
I don't know that this is an objection, but I don't think the courts admonished the jury as to any statements that were limited for the purpose of impeachment. I don't recall it if it happened that way.
Well, it didn't. This is just stock language.
We expect
which I
closings
can
today.
remove if you want it.
One rebuttal witness who will be rebutting the children's testimony.
I just don't think that this
It
happened.
doesn't pertain to our case.
No, it really
I
doesn't.
propose to take out the second long and full paragraph on page 18. Is that okay with you, Mr. Victor?
Yes, sir. That's fine.
I don't know that we've ever done that, but it's always in the charge.
Their mics are turned off, so they're picked up on a podium mic. So they sound distant.
A lot of this came from Judge Ashworth.
Yes, it did.
Okay, page 19.
It's a lot of instructions.
I hear a sigh.
Aren't we slightly repeating ourselves with this?
We are.
We are.
All possible doubt.
Mr. Truman has always complained
I
about
do a lot
that.
of whining about that. Yes, that's true.
It inures to your client's benefit, but I'll take it out. What is it that you want removed?
The last
Everything.
paragraph, starting with the state is not required to prove guilt beyond all possible doubt.
Okay.
We've heard it before.
Okay. Is that all right, Mr. Truman?
Oh, yes. Thank you.
Okay, now page 20.
The only thing in this is when it's a murder case, you must not discuss or consider punishment. And the court has, a few pages before that, has discussed punishment in terms of what happens if the jury finds the defendant guilty of the indictment. I I don't really know how to reconcile those two things. It's a proper statement of the law.
Well, I can just remove that squib altogether. I don't know that we have to have it.
Well, judging by the prior instructions, and because it's murder in the first degree, I think that the jury will, by virtue of the nature of the charge, have to discuss the punishment.
I propose to just take out the line, you must not discuss or consider punishment or permit any speculation concerning punishment to influence your verdict in this case.
Of course, there is this involuntary manslaughter, which, by the way, I don't think that the jury should ever be advised whether it's a felony or a misdemeanor, but...
I don't think we should tell them that.
Right. And
I'm going to remove this line.
But that line is superfluous in a murder case.
Okay, anything else on page 20?
Nothing from the state, Your Honor.
No, Your Honor.
Wallflower, congratulations on 23 months. 23 months.
No.
No, Your Honor. Will the court advise the jury on the selection of the foreperson?
Oh, yes.
Done later.
Sure. Okay. Now I'm going to have my trusty law clerk Colleen redo this, and I need some help, especially from you, Mr. Victor, because some of the instructions you read into the record from a book or from rote, and she will ask me what I want in there, and I wasn't able to write down everything that was pertinent.
I'm at the court's disposal.
Okay.
I'm at the court's
All right, I'm going to revamp this, and we'll get ready for the jury. Hopefully they'll arrive at 10 o'clock as instructed, and we can go forward.
Okay.
In terms of the schedule, and again, I don't want anybody to necessarily tip their hand, but I anticipate that the state or that the defense will rest. Is that right, Mr. Victor?
It is correct, Your Honor, yes.
And then the state may have one rebuttal witness?
Yes, sir.
Okay. All right. Let's get to work, and I'll need at least Mr. Victor, if not all of you, to help us straighten out some of the elements and some of the charges for the jury to consider. We'll take a brief recess.
Brief recess as they take a break. This was quick. It was actually fairly quick. Going over the jury instructions, I was a little disappointed to hear there are like 23, like 24 pages of jury instructions for a trial that has one charge. That seems like a lot. It seems like a lot. So even towards the end, it sounds like some of the attorneys, both prosecution and defense, were saying, you know, it seems to be getting repetitive here. We're sort of saying the same thing again. So it might sound that way when they're read to the jury. Are there lessers included? I'm confused on that. Jeremiah, I'm also confused. It sounds like the defense asked for a lesser included but did not get it. So my understanding, as I heard it, was there was no lesser included. They wanted involuntary. No, what do they want? They wanted. What do they want? Negligent homicide or something like that. We'll see. We'll see what happens here. Let's see. Involuntary manslaughter. Did that get in? Because they went back and they read the charge and they said there are two options. It's guilty or not guilty, and that's it. And then they sort of moved on. Negligent homicide. I thought they got involuntary manslaughter. I don't know how they could get involuntary anything on this one. That's like an accident, right? Involuntary would be an accident. I was, I didn't know someone was holding the wires on the other end when I plugged it in and it fried them. That's involuntary manslaughter. They got involuntary and you removed voluntary. Okay. Becca says, hey, super random question. What's your recommendations for hanging a large picture about a staircase? Above a staircase? Hire someone else to do it. That's my first recommendation. Ladders on stairs are terrible. It's a terrible idea, although you think that it would be good because, you've got the step and leaning into you could have tons of support and it won't slide the bottom. But just be careful. That's all. Get a stud. Yeah, get a stud to do it. No, hit a stud. Although, growing up, we had a tapestry hanging above our stair. We had a stairway that goes down and turns at the end, and we had a tapestry hanging on that wall. Beautiful, beautiful tapestry. My mom got it from the, you're never going to guess. She got it from the mortuary. They were throwing it out, and she's like, "That's a beautiful tapestry. I want it." So she has this beautiful tapestry. I forget what it is. It's like an old-fashioned, people farming, in funny shoes and hats and things. But it's a beautiful. It sort of has like an Italian feel to it. But that hung over our stairs. I don't remember who hung that up though. You're going to say a funeral home or a church. Okay, so you would have guessed. I don't know where you normally get tapestries. I didn't realize the funeral home was like a regular. It's like, well, I'm going to head down to the funeral home, see if they have any tapestries. But all right, so we have a little bit of time. We might be able to court hop just briefly. We've got about 20 minutes before the jury shows up. For those that are missed a little bit, we are on what we think might be the last day of this trial. We are expecting the state to arrest as soon as the jury shows up. There will be then one witness on rebuttal we expect the defense to arrest. I always mess that up. We expect the defense to arrest as soon as the jury shows up. And then on prosecution, they have one rebuttal witness. This is an investigator. I think it was Investigator Hines, and he's called to rebut the testimony of the children. Basically, I think they're going to try to impeach the testimony of the children, which I'm sure there are going to be some objections on because that doesn't seem proper. But, it's hard. We all felt that the children had possibly been encouraged in a certain line of testimony, that they some of their testimony seemed to be coached, that even though they were very, in the case of the son, very young at the time, having a very clear recollection of specific terminology and words and understanding of occurrences that seems to match perfectly with the theory of defense, which sounded fishy. A lot of us, we feel bad for the kids. It's terrible watching them up there, but it sounded fishy. And anyway, we'll see what the rebuttal does and how the objections fly. We're at, 118 objections now. I'm sure we're going to be around 125 or so at least before we finish this out. Okay, let's see. Google says tapestries can be found in homes, churches, castles, and palaces. Well, add mortuaries to the list because that's where we found ours. I think the detective will say something about not finding cabinets full of pills and the like. That would be easier. I'm wondering if they might also testify to, would that be hearsay? Testify to what the kids told the detective at the time? Is that a possibility? What's the latest on the Kohberger case? Just going forward, let's see. We watched the hearing sort of together. Red Pen could probably tell us. Red Pen, do you want to give us the scoop and the lowdown? Kohberger tried to get almost all the evidence thrown out. Literally, almost all of it. Basically said that because of the rule violations that the state did. They have policies, internal policies and things like that, and some of those were violated. They went and accessed databases that they shouldn't have accessed, and they did it without a warrant. But they said because of that, all the evidence leading up to that, basically everything that pointed to Brian Koberger should be thrown out. The DNA, the match they got on the DNA, the search they did on that database, they didn't have a warrant to get that. And it's interesting because I think the laws have not caught up with where we are technologically. And because of that, it may be down the road that this is a major issue, and this case might bring it to light. But BK claimed every step of the IGG required a warrant. The judge basically, I think he's reserved ruling on a lot of it, but he also laughed at it. They want to toss the IGG evidence so the dominoes and all the other warrants will be invalid. Judge seems to side with the FBI and law enforcement on evidence gathering. Tip from the ninth chief. Yep. A California case. Not for our channel. It's a bit it's spicy in the wrong way. Mel, I hear you there. That's a lot of people felt the exact same way about that. Sloth Life, I think what it boils down to is legally they don't need a warrant for that. And the judge questions Brian Koberger's standing on this. Said, do you even have standing to raise an objection on that, because it wasn't his DNA that they sought and got. They were getting a relative's DNA, a cousin's, a dad's, somebody, and obviously they share DNA, but the DNA that returned was somebody else. So if it wasn't your DNA that was improperly collected, to even have standing to object. It was interesting arguments. Let's see. There's no expectation of privacy when you sign up and give your spittle. I wonder how much it spells out the terms and conditions that no one ever reads. Right. I have not looked into that. I don't know. Was it 23andMe? Was it Ancestry? I don't know which database they accessed. And of course, it's going to come out in court more. They're going to talk about it more. There was also, they objected to the garbage. The DNA, they said, you went through our garbage. First the allegation was you came and stole the garbage that was put out. And they didn't. The garbage man actually came and collected the garbage and then gave it to the police. It was all prearranged, but it was the garbage man did the pickup. And saying you still have, rights to expectation of privacy for your garbage, I think this has actually been settled at a Supreme Court level, that once it's put out on the street, you don't. It's not yours anymore. The garbage objection was rich. It was awesome. They used GEDmatch. There used to be there are some places that say that if you put something out to throw it away in the garbage, that the public, somebody driving by, can just come and take it, and it's okay. There are some states where that's the law, and that seems a little weird because I don't want all my junk mail and stuff. If I don't shred it and I stick it in my garbage, the idea that somebody, as soon as I put it on the street, they come by and just grab that and they're like, oh, I'll take this. That seems wrong to me, but maybe it's my fault for not shredding it and incinerating it. I do tear up a lot of them, but I need to tear them in smaller pieces. Putting your DNA online is no different than putting a picture on Facebook. They can be used against you. It's in the public sphere. But doesn't Facebook at least require a warrant? They require the police to provide a warrant, right? And then they'll cooperate fully. Hubby advises our garbage, advertises our garbage, puts signs on it. Good for camp. Still works. He loves when people take our garbage. We set up a camera, a live stream camera, when we were getting rid of our clawfoot bathtub from our upstairs bathroom from the previous remodel. And it went so quickly that I could barely get the camera up in time before the guy had loaded it and taken it. And that thing weighed like 900 pounds. It was heavy. Was it in the street, or was it technically still on his property? I think that was the debate. It was on the driveway, I think. It was in the position where the garbage men have historically and repeatedly taken their garbage from. It was placed out for collection. So whether that was still technically on his property, even if it was right next to the street, I'm pretty sure there's a right of way or public access. I think it's not going to be they went up to the house and got it from the house. Most garbage men don't do that. My garbage men won't even walk 5 feet. If I don't have the garbage like right up at the end, they just pass me by. Okay, got a call coming in. If I can plug it in.
Call from Debbie Cook.
Hey, Debbie.
Hey, I'm changing the subject.
I didn't give permission for that. I'm just kidding. What did you want to talk about?
I started talking about this in chat, but it's too much to type, and I have to talk to somebody about this because it aggravated me. The behavior panel did an analysis of Melody Ferris's soliloquy at her sentencing.
Mm-hmm.
And they confused Chris and Scott. They thought that Chris was Scott, and then they kept calling Scott Haynes. I don't even know who Haynes is. I guess it was one of the cops or something.
He was an investigator.
So the whole
time, yeah.
So the whole time that, that she's like accusing Scott, they're analyzing Chris as the the accused murderer. So it's like they were getting things right about her and her body language and like the no tears and how like it would be there, like her voice would be like shaky or breaking or whatever, and then it would like immediately stop. Like the acting part.
Right. If I remember that portion of the trial, you had Melody Ferris as you're sitting. She's sort of like on the right as you're looking at her, right? She's on the right. Scott was like 2 rows back in the middle, and then Chris was far left. So Chris was looking back at Scott, looking back into his left at Scott, and Scott was looking to his right to Chris and to his left at Melody.
Right. And when she started talking, the camera panned to Chris first. Yeah. I guess that's why the behavior panel thought that was Scott.
Yeah. The cameras were not synced to the topic. It wasn't like we had the crew that was like, as soon as they mentioned Scott was on the screen. And that's probably what threw them off.
Right.
It also sounds like they probably didn't watch the case because both of them did testify and we got, plenty of time with them on screen.
Right.
But
and see, that's the thing. Every time they did the same thing with Karen Reed. They're like, why are they talking about her bumping his car and breaking her taillight? I'm like, oh my God, that was the whole case. I'm like, you guys need to do more research.
I don't know. I have not seen it. I don't fault them. I've made plenty of mistakes, and I can say that in that case itself, I also confused, just in speaking about it several times, Chris and Scott, just like in my head, because I'm terrible that way. It would be. I haven't watched it. So
That's true.
I'll reserve. I realize what they do is beyond what I do. I find it interesting. Obviously, the courts don't really find it.
I do too. I'm
the
same way.
Evidence goes.
Yeah, I'm the same way. I'm like, it's. There's no way you can do like 100%. That's what's going on, but I think generally you can get a feel. I think. I don't think you can be as specific as what they do.
I don't know. I realize it's sort of an art and it's subjective, but there a lot of times, and I haven't done much with the behavior panel. Obviously, Dr. G is sort of like my go-to guy on sort of reactions and help me understand what they're telling me when they're not talking. And there are some times where he can put things into words and saying, this is what I'm picking up off that person. I'm like, that makes sense to me. Like when I see that person, I can't understand why I think this is what's happening. And he's able to spell it out. I believe there's some truth to it. It's obviously not evidence admissible in court. But I don't fault the behavior panelist at all. The TBP, sorry, at all, because I think in a way it can be more helpful to come in and do that sort of analysis without the knowledge and the background. Just saying, I'm going to walk in and just read the room. So it sounds like that's what they did and just made a mistake.
I think that's why they make those. And when I say mistakes, it's not really mistakes. They're coming in like cold, just trying to read it. Yeah, like Ossie said about the guy, well, the kid, like how old was he? Like 17? Yeah. The kid that his parents found like human body parts in his room. Now,
that's a crazy one. He like full on just admitted that to the police, right?
Yeah,
that was a weird video.
And he did it so matter-of-factly, like he was talking about his day at school or something. Yeah. That one was dead on, but I think anybody could have looked at that kid and knew that he was autistic and probably whatever else.
It's outside of my area of expertise. I can't criticize really anything. I've made enough mistakes that I'm glad people don't pick me apart for what I do wrong.
That's true.
So
that's
awesome.
true.
Debbie, thanks. Good talking to you, though.
Yeah.
All right, we're going to change the subject back. We'll see you. Bye.
Okay. All right. Bye.
All right, we're back. All right, let's see. Jury instructions are now out of the way. The only thing I don't like about them is they're very long. We're going to be read at normal speed, one-time speed, and we'll have plenty of time to grasp what the judge is saying as he speaks. He's not a quick talker. But what about Colin Griffith? I don't know. I don't know where we're going to go next. I probably should, because we're almost to that point. I think by tomorrow we need to know for sure. Let's see. Let me see if I can get everything. Amazon wants me to... Do you guys know what Amazon Haul is? You've got Amazon, who's like... You've got Walmart and Amazon, so sort of like the two biggest stores in the world, right? One online, one physical, and online. Why in the world does Amazon want to become Temu? I cannot figure this out. They sent me this. Hey, you should join Amazon Haul. Shop on Amazon Haul. It's Temu. It's Temu in an Amazon package. I don't get it. That's a collaboration where you lose value. It tarnishes the Amazon name. All is terrible. Temu is better. It's just kidding. That's funny. Yeah, if you're just chasing the buck, though, you're chasing the lowest common denominator, and I think it would be better to improve your product and reliability. And I mean, Temu's return rates are low because it's such a pain in the butt to return it, not because the items are good. Anyway, like Temu, as long as you're not in a hurry to get it, because it comes on boat. All right, we are waiting for court to return. Got a little bit of time here before the jury shows up. Just about 1 minute or so. Yeah, Judge Boyd's live. too many things on Temu are on Amazon. They cross-post. There's a form of retail arbitrage you can do. I'm not saying that I encourage this, but the fact of the matter is people on one platform will pay more for something than people on another platform will. And if you find widgets for sale on Temu or for sale on Amazon for $5 and people are willing to pay $10 on Temu, you can list them on Temu, and when you get an order, you buy it from Amazon and ship it to them. And then you collect the difference. It's a tough business model because the terms and conditions for almost every store are fighting people to do who do that. Like Target, if they find out that you're reselling stuff that you buy at Target, they will ban you from buying at Target. Seriously, you'll be in their black book. You are not allowed to shop here anymore. All right. Alita, thank you. I saw that link come in. I haven't had a chance to look at it yet. What did I say about Target? Target, there are times that Target sells products or has a clearance on items that is below the price point that people are currently paying for it on Amazon. And so you'll get someone who goes to Target who wants to buy a bunch of these products, whatever they are, widgets or whatever it is, and they'll buy them and then turn around and sell them. Well, Target's their computers track people like that, and they'll try to do it with like the Target card and everything. So you get bonus, you get discounts, you get coupons, they combine everything together to lower the price of the purchased item, and then they'll turn around and sell it and make a profit on Amazon. Target hates that, and they will shut you down. They will prevent you from shopping there anymore. They'll say you're not allowed here anymore. Temu purchase delivered by Walmart. There you go. All right. Any second now, the jury's going to be walking in saying, "Where are our donuts?" The judge, I'm sure, has provided something for them this morning. Have they rested yet? Not officially. They're going to rest in front of the jury. The state rested. Defense, we had 2 days of defense witnesses. We saw both the kids take the stand, some friends. The first day was like people who were close to Natalie took the stand, and Michael, and then the second day we had 3 experts, and all doctors. Like it seems like we've had 6 MEs testify in this trial. It's wild, but they took the stand yesterday, and now the defense is going to rest. Natalie changed her mind on Thursday. The indication was she was going to testify. On Monday, she changed her mind and decided not to testify. So they're going to rest in just a minute. As soon as the jury comes back, then we're going to have rebuttal. 1 witness, which will probably take less than an hour. Then we go on to jury instructions, and probably right after lunch, we're in closing arguments. So we'll be in verdict watch this afternoon. In my opinion, I used to do that. That's why I know a little bit about that. Although I'd also shop at thrift shops and do it with used items. Used items are a lot easier. And in my opinion, there's a bigger markup. It's just harder to replicate because you can't find like 500 used widgets to make $10 each on. You find 1 widget here and 1 thingamadoo there, and so it's a little harder. Why would they ban them? Because it's their product being sold somewhere else, and they don't like seeing their products for sale on eBay. I don't know. I really like widgets. It's just an example. I think Colin Griffith is one of the ones we're looking at right now. I don't know. I won't know until this one's over. Ooh, steak and eggs. That would be nap time for sure. That would just put me right to sleep. Made a little side hustle reselling sports cards during COVID. Ayden, I didn't know that about you. You were flipping trading cards, huh? Well, they call them trading cards for a reason. They're designed for that. I watched a TikTok today where somebody pulled a signed Kobe Bryant, like rookie card or something. I don't know what it was, but he was pretty excited about it. I don't know who Kobe is. I just know people say Kobe when they miss a shot. Teenager killed father and got away with it. 1 year later, killed his mom. Whoa, that's the Colin one? Yeah, the first time you got lucky. Second time, now it looks suspicious. They'd say Kobe when they take the shot, not miss it. Oh, I was connecting the action with the result. They say Kobe and then they miss the shot is what I've seen. Liz, we're keeping an eye on Karen Read. Obviously, I think it's going to be a different case this time around. I both love and hate the Karen Read case trial. I'm not about the drama. There's a lot happening outside the courtroom that I think detracts from the case and is not helpful to those of us who like to watch court. Let's put it that way. I don't like that part. I am interested in the new evidence. I am interested in what the vehicle has, if they're able to get more information off those chips. I'm interested in what happens with the testimony from a police department who, in my mind, has some problems. And the investigators have some issues. How that testimony is going to come in or how that's going to look next time around is very, very intriguing to me. I want to see how that goes forward. So that part I am interested in. I realize the decision's been made already about whether or not the jury's actions constituted a verdict or not, and so I'm not refighting or litigating or fighting that issue. I might not agree with it wholly because it does seem like the state snuck one in, but yeah. All right. We've got other things coming up. We've got Corey Richens. She had a hearing last week, evidence hearing. That case is coming up here, well, before you know it, just a few months. And then Brian Koberger. I can't believe Brian Koberger is going to happen this summer. It's going to be wild. If we could do Karen Read without the drama, I would be a big fan of that. Ashley, the new motion in the Karen Read trial filed by the defense about the missing evidence, about the Sally Port, whatever, the car video. I saw that. See Danny's stream. I met Danny one of the Corey Richens hearings when I traveled out to Utah. We did a couple when I was out there. Met Danny there. Danny's awesome. I love her fiery intensity. Lafferty is amazing. Yeah, Danny doesn't like her at all. She's got Corey. Corey has a lot of personality, and she's got a lot of nerve. But we'll see what happens going forward here as that case gets closer. I thought we were here for the drama. We like courtroom drama. I love a trial where we have, good arguments, great, four-dimensional chess matches played out in the courtroom in front of the jury and the judge. Even some personalities on the bench with the lawyers, the defense. I love that in the courtroom. Everything that happens outside, I think if we focus too much on that, it sort of turns into a circus, and it cheapens it. I like spice and good lawyering. That's a good way to put it. But sometimes I'm not just here for like a conviction and somebody get legally body slammed in a courtroom. I love the compassion and the wisdom of a good judge who can read a situation and come up with even if there's a conviction, come up with a sentence that is crafted for the defendant within the confines of the law, that give justice to the victims and give the defendant the best possible opportunity to turn their life around. I love all of that. Oh. It's a late start here. Might have been steak and eggs. Karina, with the name recognition in this case, there's a good chance. Nevada has a lot of cases that are televised. I bet it would be. Let's see. I like when Judge Simpson gets mad. Oh, Barb, we can't. Even if that was televised, we can't do that here. That's a terrible one. Sherry, we love having different opinions here. So the whole idea of this chat is we do have people who think differently on both sides of a particular trial. And we just ask that both sides be respectful as they share their opinions and respectful of people who disagree with them. You don't have to change your mind, but as long as we can have an intellectual, respectful conversation, I think it will help everybody. I think it's next week, but I have not. I'm supposed to be getting contacted by their editor, and I have not seen it yet. Let's see. I'm just looking to see if there's another email that's come in. There's not. Ooh, there's a crime con in UK? In London. I couldn't afford the one in the United States. All right. Judge, we're ready. If you can bring the jury. I think Courtroom Confidential should be airing next week. I just have to wait and see if they need more more pictures, because they do a lot of editing to really make the video professional. So if I talk about certain things, they might say, hey, can you get us a picture of your college, you know, that you went to school at, or, you know, whatever. And so I'd be doing that.
Bring the jury.
So the interview will be a week from tomorrow. Awesome. We've already shot the interview, and it was great. Josh is amazing. Had a blast. Hopefully we can do some more stuff together. Oh, look at this. You guys, I've got a collab request. Let me share this with you. Special collab for Recovery Addict. Hey, a few days ago, it says, hey. This is how the email starts. Hey. It sounds professional already. A few days ago, I wrote to you on behalf of company regarding a potential collaboration, but I am still waiting for a reply. We're interested in helping Recovery Addict by providing experts and materials to make a real story. We can help you create powerful content like we did for Planetawan from Canada. His video, created with our support, received almost 400,000 views. And it's got a link to a video about war in the Ukraine. We have a lot of ideas for you to cover events and life in Ukraine. Oh, they have an agenda. They have an agenda. It's a real story. Are you interested in joining our efforts to be the top of YouTube while supporting Ukraine? Send me a message and I'll tell you about all collaboration options. If you're not interested or collaboration with us is irrelevant, you can unsubscribe from our emails. So he's admitting that he's sending everything to a list. Yeah, I'm not doing war videos. Click the link, says John. No. I get some crazy invites like that. Hey, bud. All right. Should do a collab. I think eventually we're going to do. Runkle got the same one. They should just send everybody. They were supposed to start at 10. They're a little late. The jury was told to be here at 10. So if there's any weather issues or one person's delayed, that would cause this. Yeah, I ignore all of them. I don't click on subscribe. Back to this case, Liz says, did they ever get into their documented seizures? We did talk about the seizures. The defense witness said that they began on the 6th, February 6th, which was like the day before he died. Is that the one you're talking about? Michael wanted to be a pilot. And one of the things about being a pilot, there's a test involved that involves skill flying. You have to have the skills to operate an airplane. There's also a lot of knowledge involved as far as reading flight maps and rules and FAA, regulations and everything. All that's there. And there's a physical. Pilots have a physical involved. And if you have certain conditions, it may make it so that you are not allowed to get a pilot's license. You wouldn't be granted a pilot's license. The last thing you want is somebody to be up in the air and have one of their recurring episodes of some sort of ailment, and then you have, that would be awful. See, I cannot do it because I would fail the vertigo test. I cannot do a somersault, or I won't be able to stand up for the rest of the day. Inner ear does not work like that. I can't even do, I think, virtual glasses because I just get so confused. I just fall over. It's like thump. You can't fly with a seizure disorder. So if he did have seizures, and he was trying to get his license. He may have been trying to hide that fact from authorities like his doctor, who would, possibly be able to report that if asked by the government. OG Sean White says, I'll do a collab with you on how to speak Bostonian. We need the Boston accent like me for Karen Reed trial. Is it Boston? Boston. It's not how to speak it. It's how to understand it is what I would need. Delana Forrester, member for 8 months. Never know what to say here, so I'll just say hi and hope everyone has a great day. Delana, that was perfect. It was perfect. I love it. Don't think he can even have documented depression. I know there are some medications he can't be on. There's a lot. The best I can probably do is get my Part 107 to fly a drone, because there's no physical required there yet. Let's see. Ari is like the fainting goat, just falls over. Yes, Debbie. Spitting image. Spitting image. Just thump. That's me. I like to blame. I was actually in gymnastics as a kid. Here's a fun story. My mom put me in gymnastics, and I think I did somersaults as a kid. Like I remember doing somersaults like on the floor, like, somersault around the room or something like that. And I was fine with that. And so I probably had a lot of energy. She's like, maybe gymnastics would help. You can get some of your energy out. So I go to gymnastics. I remember one class, and it was day one. And I know they wanted us to do like a flip, like a standing flip. I had never done a standing flip. And so they're like, okay, you stand here and jump. And I basically jumped and landed smack on my head. Just bam. And they're like, try again. And I'm like, and I'm like, jump, and landed smack on my head. I'm like, this is not for me. And since that date, I've never been able to do flips. I cannot go on a roller coaster that goes upside down. Nothing. I need the sky up and the ground down, or else I have major problems. Were you ever on the U.S. national team? As probably explained, no, I was not. My youngest son is like, hey, watch me do a backflip on the trampoline. Stuck the landing. I was like, just learned that. I'm like, when? Right now. So he's got all the skill I do not have. But Pauline, member for 21 months. Thank you. Welcome to the gallery. Let's see. I did gymnastics too and ballet. Got kicked out of ballet though. My sisters did a little bit of ballet, I think about the same time that I was doing gymnastics. I know enough that I know their words plie and releve, but I'm not sure which one is which. It has to do with which way your toes point. Nick, I don't have any updates on Maya trial. Mathis does all the reading on that, and if there's something big, I'm sure he'll tell me. Rona, member for 16 months. Congratulations. That's awesome. Love your goofy picture there as well with the feet hat. That's awesome. What a terrible coach you had. I think it was probably like one of those community sports events where the coaches are actually just kids who are a little older than you. I don't remember much because I hit my head so hard. I don't remember. I'm not even sure if there were mats. I'm pretty sure it was just like on the gym floor. Everyone, okay, do a flip, and I'm boom, concussion. Let's see. In order to understand, you must learn the lingo like wicked pissa means it's awesome, or packy, it's a liquor store. I'll see drop the R's, it's kapak. Wow, it's wicked. That's also was used over in England a little bit. How many siblings? I have all of them. There are 10 of us. As you will hear in the interview with Josh. Plie is down, releve is up. Oh, it's the point the toes? I thought it was whether or not you turn your ankles out and your toes in, or your toes out and your ankles in. Does anyone remember the rope burns during gym class trying to ring the bell? No, I remember climbing halfway up and looking down and saying, wow, that's a long way down, and like freezing. I'm like, I don't know why, but now I can't go down either. I'm just stuck on the rope until my arms give out and I'm going to fall and no one will catch me. Gymnastics was traumatic on me as a kid. Kiki D's Garden member for 19 months, turning 41 tomorrow. Should I freak out an hour later? Later. Give it a couple of years. Let it set in. You're good. Let's see. They lurk. They lurk. I was on the podcast, last week? And I was talking about a stethoscope that I got sent from a customer back in a business a long time. I don't even know why the story came up, but I popped in my head and it came out my mouth without ever thought. I'm like, I don't even know where that is. And she texted me. She's like, I've got your stethoscope. So I think she watches occasionally. I had a traumatic childhood with athletics. The only athletics I really enjoyed, and I didn't enjoy it at first, was running cross country. No, two things. I did the swim team, and that was like junior high age. And then I ran cross country. Here comes the judge. It's about to kick the door open. There we go. Loved both of those.
Good morning, everyone.
I'm in the middle.
Good morning.
Good morning.
And we are continuing in the trial of State versus Cochran. We have been working busily on instructions, and I have a draft that I have handed out. Hopefully, Mr. Truman, you've got a copy there. Okay, I'm not rushing you. We'll have some time to discuss it. I just want to make sure you got your copy.
I did. Yes, sir.
All right. Any matters to take up at this time before we bring out the jury and continue?
The state will need the equipment for the next witness.
Okay. We'll fire that
Bring
up.
the bailiff. There he is.
You go with. Yeah, and I will carry.
I've never seen handcuffs carried that low on the duty belt. I know I commented before.
All right.
They like smack you in the butt when you walk. I've always seen them higher. But kids are not here. They might not be in. There's the approach. Mr. Victor with the blue jacket, black pants, white shirt. Is that a baby blue or is that a gray? I can't tell on my screen. Looks like a gray suit for his partner. Night. Don't judge. Okay, I won't. I call gray. It's duck egg. It's blue. Okay, we need a pole. Is what we need. Okay. I hopefully spelled it right. The poll's up. What color is the Secretary of Defense's suit? That's the lightest color suit up there. Wait, says Blackbird. This is going to break the internet. It's not like the shoes or the dress. I think you're good. Angelique, the rebuttal is to counter the testimony of the kids, and I think that's why the kids are not here. That would not be fun to hear your. Oh, is that an Atmos? Looking at the hardware there. I'm going with the baby blue with the gray pants. Oh, you're splitting the difference. Lunar rock is the color. Okay, so that color of gray has become popular in vehicles. I know you can get it in like a, I think you can get it in a Ridgeline. I did see tech. It's got a lot of ports on it. You've got an SDI feed. She's got power and SDI, and then I think she's got her headphone also coming out of the back. So SDI in, power, and then headphone. Plus yesterday's dramatic pictures of their dad. Right. Would blue-gray be some other color? Yes, it would. I love my two Pickles. I don't know what their name is. Oh, the two pups. I've never seen a defendant go to the bench, but then us in the UK can't watch any of our trials, so I have to stick with our friends in the US. There are some states that allow it. Florida, for one, says that the defendant has the right to participate in all substantive portions of the trial, and bench conferences are included there. Most courts use headphones if that's a requirement, where the defendant can put on a pair of headphones and hear through a microphone what's happening up there. But in some, they approach. And here's one where she approaches. Do you have that color of Ridgeline? I've got a friend with one as well. Did she testify? No, she did not, Jessica. She changed her mind. There's a rare shot of the gallery. Seeing who's here today. I'm actually here for the media and the tech guys, although he's got a blanket over all his gear there. Running the switcher there. Audio guy next to him in orange. And producer on the end. Beeshins. I missed it. Was Lawyer Lee there? She's been there most of the days. Meg, congratulations on 18 months. Did I mention it's 76 degrees in Southwest Florida today? No haters, please. You can always come visit. We're gonna do a poll, not after closing statements. We're gonna do the first poll right after the evidence portion is done, and that's gonna be the rebuttal. At the end of rebuttal by the state, assuming the defense does not have any, like, what is it, surrebuttal or something. Lawyer Lee's not there right now. She's back in ATL.
All right, now, Mr. Truman, if you'd take some time to select the documents that you wish to present.
Handing them to defense counsel as we speak. I'll take these back.
Okay. Whoa. That's a lot of documents. Tells the defendant, get out of here. We need let the lawyers talk. Defense is now first chair. Defendant is now first chair. What are these documents? It's got to be an interview with the kids. It's got to be an interview with the kids. What else would it be? We do have a button winner. Congratulations. And the button winner turned around and re-gifted the entire prize back to y'all with 10 gifted memberships today, which is just awesome. Looks like Panasonic and Sony as the cameras of choice back there. Good cameras, all of them. Good cameras. Could be their initial statements, an interview, what he did. He was the investigator at the time, the initial investigator. What was the button number? The correct number was 1,154. Yes, I have 1,154 buttons in my studio. The closest guess was 1,155. It's awesome. Thank you, Swanee. Yep. Bob was super generous to turn around and re-gift that back to the community. Bob, what are the lotto numbers? Says Greeners. Help out a friend. The last picture of me was taken. Me was a good resolution by Fujifilm. It even saw into my lungs as it was an X-ray. Wow, it's a nice camera. Victoria was off by just 700. You were close. You were close. I think the next closest guest was 1157. Talking to her parents, who are supporting her, even though they lost financially in this exchange. Do I know what every button does? Yes, I do, but there are, let's see, 2, 4, 6, 8, 10, 12, 14, 16, 18, 20, 22, 24, 26, 28, 30. There are 60 buttons I never use.
Sure.
Oldest electronic device by years would be my MacBook Pro, I think. It is a 2016. No, I've got older than that. Hang on. I've got an iPad that's a couple years older than that. Is that a spare keyboard? I have 2 wireless keyboards. One for the iMac, one for the Mac Studio. 2 8-port HDMI, 1 8-port HDMI switcher, 1 8-port SDI switcher, 1 4-port HDMI switcher, a Stream Deck XL, a MacBook Air, a Rodecaster Pro, the original model, not the 2. I haven't been able to afford the 2. They're too expensive. The 60 I don't use. No, they are select bus settings on my switcher, which I run everything through my Stream Deck, so I don't have to use those buttons. She's in jail right now. Well, she's in court right now. We're doing pantomime. What is this?
All right.
Are we good? She's in jail right now for the Ponzi scheme, which she was convicted of. Another approach. She did send a letter to the court shortly after she was arrested saying, I would like a speedy trial and I am bankrupt, so I need an appointed lawyer. And let's go. Sorry, my lights are doing something cool. I don't know what it is. Oh, they're stacking the rainbows. Look, let me show you this. It stacks the rainbow, like the lights. See right here? You can see the reflection, the blue. It stacks up and then starts over. I didn't know it had that function. Anyway. Defense does not want this in. Of course they don't. The kids were really good for defense because they said all the right things, and this is going to either contradict what the kids said or possibly make the kids look less than truthful. Okay. I just bought 100-foot long Cat 6 internet cable. And I want to use it to set up my camera outside so I can film people going by. Every time there's a fire truck, I could just cut to that camera and be like, look, that's the noise you're hearing. Man, it's warm in here. The defense is fighting. Fighting hard. But if they brought in witnesses to testify about this and the state has evidence to the contrary, the state has the right to bring that in. The door's opened. Lou at my last Twitter. Look at my last Twitter DM. Oh, I read that letter. Let's see. They're arguing about the documents. This is from Josephine Moore, one of the attorneys, or one of the reporters in the... oh, there's a picture. I could care less what the reporter said. I've got a picture of the switcher they're using. Marshall brand monitors. Interesting. Whoa. Okay. Let me read the message now that she said. Sorry, I was admiring the tech. Truman and Stanley arguing about the documents, I think. I heard Truman say, I'm not caving on this. Then Matthew called them both children, and now they're back up to the sidebar with the judge for a sidebar. Whoa. That's a fight. I'm not caving on this. Jury's not in the room right now, I believe. We're just waiting for the go-ahead from the two sides to be ready. Got a new mouse, and its wireless range is about 1 foot. I don't like it. right. To be a fly on the wall. Yeah. The judge is going to have to sort this one out. If they can't agree, the judge will have to make a ruling. 10-minute recess to fight it out, probably in chambers. Why did the law get suspicious? It probably had to do with their conviction for the Ponzi scheme. When you get convicted of running a huge $1 million scam, and right in the midst of it, your husband dies, I think that's something that would be like, Mama of 3, good to see you, by the way. I didn't see you yesterday, but I think I might have missed you, but it's good to have you here today. Didn't they have 2 hours to talk about this already? Yes. It's a good song too, Melissa. Let's see, just one second. Products. We did get our shirts in from Sticker Mule. Those were, let's see, hang on. We did a couple T-shirts. I like their quality. I will say though that the shirts run, they're more like muscle shirts. They run tight, but they're good quality. So why can I not see? Give me a second while I'm slightly distracted here. Sorry. Judge is fighting out the issue between these two sides. I think we're going to see some of it. I just don't know if these. I think the documents are what's in question. So if these documents are transcripts of interviews of the kids, I think that the argument would be hearsay. It's an out-of-court statement. Or possibly improper impeachment if, he should have brought it up with the kids at the time, which is always risky because you don't want to attack a kid on the stand. It makes you look bad to the jury, unless you have to. All right. Muscle shirt. So you're trying to look at bodybuilders from early in the case. Yeah. They make me look good except for the belly. I need to work on my belly a little bit. I need more definition and less curve. Is there a car chase we can watch until they come back? YouTube does not like me watching car chases. Dad bod shirts for sure. Yes. Although my son loves his, and it's not. I think we got him a adult small, and it'll fit him for like a week, and then he's going to be into a adult medium. He tried to take it up when the daughter was on the stand by asking for papers from the investigator. Sherry says, I believe the kids, everyone is coached. Megan, thank you. The only concern I have is I am small enough that I can't order a bunch of shirts and inventory them and sell them. I have to do a print on demand. I couldn't afford stocking inventory. And Mrs. R.A. does not want to do my shipping for me. Redman, I sent a boring poster for this trial. I will look for it here in a bit. I find it strange the investigator would take no notes or record the interview with the client's children, but maybe there's a reason why they don't. I don't think that's how my belly button works. They did warn the kids. The kids had left their room before they showed those pictures. Everyone was warned. Sherry, I hear what you're saying here. I felt very much the same. When the kids were testifying, they used almost verbatim the defense's theory about what happened. I mean, from the intro of the case. And either that means that the defense built their entire case around what the kids were going to say, and they knew exactly what they're going to say, or the kids, said things in a way that fits perfectly with the defense. Either way, for me, it didn't look good. All right, let's see. Here we go. Have we sorted it out?
All right. Are we ready for the jury now? State
No,
prepared.
Your Honor, we are only halfway through these documents. A lot of them appear to be unsubstantiated, irrelevant, but we still have to go through about half the documents.
Well, we've got to go forward, and so I don't want to leave the jury in there much longer.
Is it a late disclosure?
Perhaps you can review them and do it on the fly.
Well, Your Honor,
We would object.
Unfortunately, we would have to go through each and every document as they're being testified to. We need to view them.
Let me ask you this. Have you been provided with these documents?
We honestly don't know, Your Honor. We were provided with 100,000 files. I can't tell if we did or not, and we have not reviewed these prior to the presentation.
Let me ask Mr. Truman, did the state provide the defense with these documents?
We did. This is the download of the defendant's phone. We separated them, and we've already agreed not to submit all of the downloads of the phone messages that are not already in evidence. So it's down to this stack of a few right there. The state does have a suggestion.
Oh, this could be bad.
In order to expedite this, we can probably eliminate some of these, and that could save us some time.
Okay.
What number are you on?
We're on page
Good.
2.
We'll eliminate 11. I said we'll eliminate 11. No, this isn't on record.
They're engaging in another powwow.
Yes. 15. 17.
No, keep going.
18. So 11, 12, 15, 17, and 18 will withdraw.
Okay. So now, do you want to review those? Do you want to withdraw any of these?
No, I told you the ones I was willing to withdraw.
Do you want to have another 5 minutes?
We want another 5 minutes to look at those pages. These are text messages. I'm seeing text message exchanges.
Your Honor, respectfully, could we have an additional 5 minutes to... The state has eliminated a few, but...
All right. I'm going to hold you to that, Mr. Selden. I'm going to time 5 minutes.
Okay.
So now we get another 5-minute break. Text messages, and the state does not want them in, or the defense does not want them in. These could be juicy. These could have information about directions to the kids. Like, hey, remember that this happened, type thing. This could be quite a yeah. Somebody set a timer. This could be interesting. So we've got 5 more minutes. It'll be just after the top of the hour before we come back. The jury's been waiting for an hour. The state's like, I told you which ones we'll withdraw. We're not going to withdraw any others. Telling the kids what to say could be in there. Laurie, she requested a speedy trial, which means there is not a lot of time to prepare for defense. These are also public defenders who have, presumably another caseload to be working. It's a challenge on her defenders, on her legal team. And if there are 100,000 pages of documents, finding the right ones. It's not exactly trial by ambush, but you could argue that I need a little more lead time than this. Kurt's here, calling out that we are in fact in Admiralty Court because of the gold fringe on the flag. Thank you for pointing that out. Subject matter jurisdiction and all. Hey, what's up? Oh, I got some mail. I happen to have a really good letter opener. Went to the post office today. I did send off your stickers for all the people who were waiting. I got one more, so let's see. Who's this one? Fitzgerald? We'll get yours out here shortly.
Are we going to address subject matter jurisdiction?
There are stickers. Yeah, Kurt. Text me your address. I'll send you a sticker. They look like this. All fancy like. The deal is, I was having people send their self-addressed stamped envelopes to, and then I would send them a free sticker. If you don't have access to a self-addressed stamped envelope, I do have some stamps left over and some envelopes, so I can get you one. But
I was kicked back, taking it easy.
the stamps add up pretty quick, so can't do a ton of them. No, it's not too late. Send a self-addressed stamped envelope. I think I've got about 100 stickers left.
Somebody just sent me a video of roaches fighting. I don't know who won.
How do we get the address? One of our mods will type the command in chat, and then it will post on the screen for the post office box. Let's see. The stickers are 3x3. If you want a 10-pack, you can buy them on Sticker Mule. I can give you a, let's see.
I'm not a camel.
Shame on you, sir.
Okay. Let's see. Trying to
Alex
find store. Okay. If you want a 10-pack, our Sticker Mule store sells the 10-packs. But if you send a self-addressed stamped envelope to this address, I will send you a sticker and I'll cover the sticker cost. That was a quick 5 minutes. That was 4 minutes at best.
All right, are we ready for the jury now?
Your Honor, we only have one exhibit to review. If we could have 1 minute.
All right, 1 minute.
He checks his watch. Bug Dugger, thanks for the postage fund. Thank you, appreciate that. We don't have the COG audio yet. I did not work on it last night. I was supposed to, and I did not. That's my fault. What was the great comment yesterday you said about a soundbite? I don't remember. There was a guy who said,
All
just
right,
a cog in the machine.
bailiff.
Hi, I'm Cog, or something like that. I have to get that. He just called the jury in. He didn't say, are you ready? Just bring the jury.
I'll ask the defense to call their next witness, and presumably you'll rest.
Yep. Lynn.
Bring the jury.
Lynn, congratulations on 2 months. 2 months officially, 12 months unofficially. Had to start over. It's been great to be here, even if all I do is lurk in the background. That's awesome, Lynn. Yes, you've been around a lot longer than your courthouse color shows. It's a 3x3 sticker, 3 inches by 3 inches. So if for some reason the envelope you send doesn't work, I'll use one of my own. But
Your Honor, while we're waiting for the jury to come in, we would like copies of these to go through as they're being testified to.
Okay.
Let there be copies. The next witness should be an investigator, and it will be a rebuttal witness by the state, and it will be, I believe, our last witness before jury instructions, closings, and deliberation. So we should be in deliberation here soon.
Good morning, ladies and gentlemen of the jury.
They're about to rest.
I'm glad to see that you're still smiling. I apologize for the extreme delays. We have not been sitting around talking about West Virginia basketball or Marshall football or even politics. The attorneys and I have been working diligently since 8:30 this morning to try to streamline this trial and get it in a posture for your consideration. I appreciate your patience so much. We are now in a position to go forward. If you will recall, we are still on the defense case in chief. So I will ask Mr. Selden to please call the defendant's next witness.
Your Honor, we have no other witnesses. We are resting the defense case.
All right. Thank you. Let me inquire of the state if there will be a case in rebuttal.
Your Honor, the state does have one witness to call in rebuttal.
All right. Please call your witness.
State recalls Robert Heinzman.
Robert Heinzman.
Mr. Heinzman, I remind you, you are still under oath. You may have a seat.
Testifying again, second time.
You may proceed, Mr. Truman.
Thank you, Your Honor. Mr. Heinzman, hand you what's been, at this point, it's part of State's Exhibit 3. Ask you to review that as well as the second page, which is also an abstract from...
You might request that we get copies so we can look at them while they're being testified to. If we could simply copy them very quickly.
Does the state have copies available?
We do not. I mean, we can make them, but...
Okay. I'll ask Ms. Brown Bailey or the deputy to make the copies real quick. How many do we need?
He's the only one that wants one, I guess.
One.
Now they're getting all snippy.
Yes, Your Honor, one copy.
Okay.
There are all sorts of notes on these. I mean, there's like little Post-it note sticky tags and things on here. Wagner, I think you're right. I think the focus of this testimony may be the kid's testimony, and possibly Natalie's involvement in the kid's testimony, which would mean, once again, that all the testimony we have that supports her side of the argument, whether it was from doctors or anything else, is from her, is from Natalie. If she's crafted all the evidence or created all...
The court's information, Mr. Victor will be cross-examining this witness.
Oh, all right.
Ooh, we get one more chance at Mr. Victor. That should be spicy for sure. This is gonna be wild. This is gonna be good. The objection counter is gonna be flying, I think. Cookie, they have them. It's in their discovery. They just didn't bring. I mean, they didn't print out all 100,000 pages of discovery, and apparently they didn't know that these were going to be brought up. But this is rebuttal. The state's argument as to why we didn't let you know beforehand we were going to use these was we didn't know we were going to have to. Well, this gets going. I'm going to close out the poll because I think we've answered the question adequately, and it is, in fact, a gray suit that is being worn by a 60 to 28% margin. 10% said some other color. I'm sure they reviewed the discovery, but they didn't pore over everything. And when the state provided their list of evidence they were going to bring in, this was not on it because they didn't think they'd need it. Well, then defense brings the children in, they testify in the way they testify because the state had not interviewed the children, right? They had not sat down and interviewed. Remember that from the other day. They said, we didn't know that's what's going to be said. Because of what they said, now we need to bring something else in. We didn't know we were going to have to. That gets out of the late disclosure situation. And they say, we're bringing in these text messages from the phone dump. And now defense, all they can do is scream and pound and hit the table, but it's coming in, and we're going to hear it. And it's going to be spicy. In my mind, I think the court clerk has one of those old hand crank operated copiers. Do you remember those from like I remember my teacher copying stuff with those in elementary school. I remember being forced to walk down to the office, to the teacher's lounge or whatever, the teacher's like workroom, because the teacher had to make a bunch of copies and she didn't want to carry them back. So I was like the mule. It's like, you kid, follow me, hold these papers. So I have to like hold the paper, and then she'd like crank, make all the copies, and then I had to carry them back. I thought it was an honor, but I really think that it was, now that I look at it, it was forced labor.
With our luck, the copier may have run out of paper. That's right.
It's a mimeograph, yeah. I was not teacher's pet. I think the sticky notes probably got shredded. Hopefully she's taking the Post-it notes off as she's copying and then replacing them in the right place. Maybe got jammed and it shredded some of the copies. But you got out of class. But had I stayed in class, everyone in class, while the teacher's gone, just got to play and throw airplanes and stuff. And I had to stand there and hold papers and be respectful. I don't remember the smell, thankfully. It was a great smell. I guess it wasn't too traumatic on me because when I was in high school, I took a printing class where we ran offset T-head presses. I think we ran AB Dick 4-color press. That was a lot of fun. And those are serious machines. Your lungs remember the smell. Joyce, we went off on a tangent because now that the jury's here, defense has requested copies, which I guess is the state's burden, and so the state is making copies at the court's expense, and it's taken forever. Clapping the erasers. Oh, chalk dust. I have pounds of chalk dust in my lungs.
Go ahead and ask some preliminary questions.
Okay, go ahead.
You previously testified that you and Tim Bledsoe, both retired troopers, were the lead investigators in the two cases, correct?
That's correct.
As part of your investigation, did you interview the defendant's children?
No, we did not.
Why not?
At the time of the investigation, and more specifically between March and June, March is when we began the investigation. June is when we executed a search warrant on the defendant's residence. During that period, we were collecting information from third-party records. We were collecting information from witnesses, from financial institutions. And there was nothing in that 3-month period to indicate that there would be a need to speak to the children. The second and most important thing was their age. They were very young at the time. One was 10 or 11 and one was 13. And we were looking at the business of the Cochrans. We were looking at the Cochrans individually. So there was no indication or any reason to speak to the children. And then the final reason we wouldn't speak to the children is we've been long taught in law enforcement and investigations that you don't speak to children under the age of 18. And there's some tolerance there with 16, 17, 18-year-olds, but you don't speak to anyone that young without a parent's permission or without an attorney present. So we would not, by normal operating procedures, have spoken to the children.
You were in the courtroom when the two children testified on behalf of the defendant, correct?
I was.
And in their testimony, they indicated to you who actually ran the company businesses.
I did hear that testimony, yes.
And what were the children saying as to who was controlling the Cochran's businesses?
The children put a lot of responsibility or...
I'm going to object to this. The jury heard the evidence. The jury can draw whatever conclusions from the children's testimony. This witness does not need to editorialize on that.
Sustained.
You're being recalled as a witness for the purpose of rebutting the testimony provided by the children. Is that
Yes.
correct? Okay. Thank you.
Everybody has their copies.
Hand
We
you
can
an
begin
abstract from what's been admitted as State's Exhibit 3. Ask you to look at that as well as a second page, also an abstract of what's been admitted as State's Exhibit 3. Recognize those documents?
I do.
What are they?
These are text message communications between the defendant, Ms. Cochran, and Stephanie Hamilton.
Have those back, please. At 10:15, the defendant sends a text to Stephanie Hamilton. Can you put that in some kind of context as what's going on there?
Natalie Cochran is offering Stephanie Hamilton an opportunity to invest in a government contract dealing with medical equipment.
The document speaks for itself. Again, we don't need any editorialization as to what these documents are, what they speak of.
Could the state respond to that?
Sure.
That's not accurate. Those are statements taken, and they don't say anything about a contract. It says there are two today. Two what? I think it's fair to put that in context with the witness's investigation and what he found that meant.
And for that matter, these documents do not indicate any interlocutor of Natalie Cochran. We have no idea who this is.
Well, I think we do need some explanation from the witness, and so I'll allow it. I'll overrule the objection. You may proceed, Mr. Truman.
Thank you.
Ms. Cochran is offering an opportunity to invest in two contracts or to consult on these contracts. They deal with surgical masks and betadine swabs, medical equipment. Ms. Hamilton was in the medical field.
Okay. Here's another text, and this is also a download from the defendant's phone, correct?
Yes. And from Ms. Hamilton's phone.
Correct. And this is April 26th of 2019?
Yes.
And the defendant responds, that means next Friday is payday.
I'm going to object to this, Your Honor. This is way out past Michael Cochran's death. This document is irrelevant.
What is the date on this?
The date?
Yes.
April 26th. And the purpose of this testimony is to show that the defendant continued to run the business as she had before.
I'll allow it. Overruled.
Thank you.
Wow.
Trying to next hand you an abstract from State's Exhibit 2. Could identify that?
Yes.
What is it?
This is a text message between Natalie Cochran and Chris Davis on February the 6th, 2019.
Judge, I think we really need to approach the bench at this point.
All right.
I'm counting that as an objection. We're just warming up. These are getting. He storms up. I've never seen him walk that fast in the entire trial. He has a bee under his bonnet, and he's about to let the judge know. Let's see some animated argument here. Lots of head shaking. Judge with a poker face, listening intently. Got some hand gestures. Look for more head shaking. Ooh. I imagine The jury could probably hear this. He's getting animated up there. It's too far to read lips, and he's facing the wrong direction, which makes it incredibly more difficult. Okay, listen to the state. Mr. Victor leans on the bar to rest on the bench. State had a quick response. Back to defense. Not of agreement from the state. I think the state won that one. You may continue.
Continue, Mr. Truman.
There it is. State won.
February 6, 2019 at 9:27. That's a text from the defendant to whom?
Chris Davis.
We'll have these marked collectively, but if you could take a review of those documents. And if I could have this marked as States 34, please.
All right.
No, this will be State's
Well, we
Exhibit
didn't-
number 37.
We're not, those weren't allowed.
These aren't allowed?
No.
These right here.
Right.
Number 35.
Some were struck out.
What's the number?
34.
Victory for defense. Partial victory.
Or 35 and 30. 35 and 36.
So those are not going to be admitted?
These? Well, the ones that you marked previously are not. It's this one in its stead.
Okay, well, it's going to be 37 because I can't.
That's fine. Sure.
Can't take the sticker off.
This is Defendant's Exhibit number 37, Your Honor.
States.
Thank
I
you.
mean States, I'm sorry.
States 37.
Yes, sir.
Okay.
Thank you. States 37, marked for identification. Tell us what that is.
These are text messages between Natalie Cochran and Wendy Poteet.
Who's Wendy Poteet?
Wendy Poteet would be the sister of Natalie Cochran.
And how did you acquire those documents?
These documents, they're cell phone text message documents. These were recovered from Natalie Cochran's cell phone subsequent to the search warrant executed at her residence. The cell phone is given to a forensic examiner and they do an electronic download of all the data on the cell phone. And these are pages from that extract.
And that was from a search warrant?
Yes, sir.
Now, we don't necessarily have to go through all of these. Let's just put a few up here to show where this is going.
He's got the delivery of somebody who's about to lay down a trump card.
4. Oops, can't get anything out of that.
If Phil's selling them, you know they're good quality. I highly recommend them. But I sell them cheaper, though. All right, let's see what this says here. Love you to the moon and back, forever and always. Your, I don't know, pumpernickel. I can't say what this is. Your.
Once again, these are text messages between the defendant and her sister?
Yes.
And she's offering a contract?
Wendy Poteet was already an investor victim of the contracts, and she is.
We object to the characterization investment victim. We don't know anything about Ms. Poteet.
All right, that's a fair objection if you'll refrain from speaking of her as a victim, please.
Yes, Your Honor.
Continue.
Wendy Poteet was an investor, and this is reference to a contract that she is owed money on. And Ms. Cochran is advising her that she's going to be paid by certified check.
Did that ever happen? Asking for a friend.
Once again.
This is a text message.
Your Honor, can we please have this identified? Which document?
Number 5.
Text message, again, between Natalie Cochran and Wendy Poteet, where Natalie is offering additional contracts for Wendy to invest in on February 18th of 2019.
Now, collectively, is there a pattern emerging here in terms of the defendant's conduct of the business?
I'm going to object to this question. That's argumentative.
Or we could just go through slide by slide.
Overruled. Continue.
Is there?
The state saying
These contracts were dated after the date that Michael Cochran collapsed on February 6th. So this is a continuation of these illegal business operations, the investment, the Ponzi scheme that we'd spoken about. This is a continuation of those after Michael's not available.
This time for sure. Please.
This will be State's Exhibit number 38, Your Honor.
Very well.
Before I go south of these.
Before I go south of these, something about a bad feeling? What?
Let me get that back. Take this.
This filthy rascal.
Handy what's been marked for identification is State's 38, please.
Here comes an objection.
You recognize that?
I do. I do.
What is it?
Which number is it?
Oh, I'm sorry.
For the
Yes. Yeah. 22, 23, 10, 13, 14, 16, 19, 20, 21,
Okay,
22,
so now we're
23.
looking at 10.
Collectively at the moment. But
Okay, all right.
That little threat by the states. We could go through all of them individually.
they're not all available, but exhibits 10 through 23, or tabs 10 through 23. What is that?
These are all text messages specifically between Natalie Cochran and Michael Cochran, ranging from August of 2018 to February 5th of 2019.
5th or 6th?
These end on the 5th, February 5th of 2019.
Okay, let's see what this is. Michael's text. Yeah, this is going to be truly insightful, I think.
This is page 2 of number 11. Who's that to and from?
This text message block is Natalie Cochran's text message that she has sent to Michael Cochran.
3.45 million should post tonight at midnight from Pay Simple.
Do those numbers mean
300,000
anything
should
to
post
you?
Wednesday. 1.25 million DoD
These
Thursday.
are dollar amounts that she has told Michael are owed to them and their business for contract, government contracts that they have sold or obtained, been awarded would be the correct term. She's.
Are you done with that one?
It doesn't say that. It doesn't say here are the contracts that we should be awarded.
It
could post the winner of the bid.
You want me to finish, Mr. Truman?
Please. Yes.
The date of this text was on August 27th, and with these dollar amounts, she's provided other dates in which these dollar amounts will be posting. The very first entry, 3.45 million, should post tonight at midnight. That would be on August 27th, and then there's timestamps applied to the other amounts in those texts.
13.
Tonight at midnight? Don't most transactions go through during the day?
And this one from October 25th of 18.
This is a text from Natalie Cochran to Michael Cochran where she's talking about getting off the phone with government entities and that the audit, which was presented as a reason why none of the contracts could be paid out, she is telling him at this time that the audit is complete. There's some additional administrative stuff that needs to take place, and that all monies from all those contracts that he believed were being awarded and due will be available by Monday, October 29th.
They have been holding the ones I was awarded.
You heard young Mr. Cochran testify about a .50 caliber contract, did you not?
I did.
This is number 14.
He helped his dad get a .50 caliber contract at 10 years old from laying between his parents in their bed at night.
This is, again, a text. You recognize the phone number as to where that text is coming from?
Yes, that's Natalie Cochran's phone number.
And is that the only .50 caliber order in your investigation that you saw, or were there others?
That is the only one. This is a reference to a text again to Michael about that .50 caliber government contract order, where she is telling Michael that they, being whatever entity the contract was fulfilled with, want to double that .50 caliber order, and it would cost them $244 million and yield a return of $378 million.
I remember the batch files running in the evening. I didn't think they posted at midnight, though. I was on the other end of that.
19. This one from January 30th, 2019. Who is that one from at 334?
Again, this text is from Natalie Cochran to Michael Cochran. In this text, this is following the government shutdown, to put it in context. And she is telling Michael that they have all the money being resent tomorrow, and they should be available to them by Monday at the latest. And then the feds will begin sending money on Monday. This was dated January 30th of 2019. February 1st was the date that the investors had been told that the monies would be released post government shutdown.
There's one from the 31st.
This is, again, a text from Natalie Cochran to Michael Cochran where she is telling him that she is on the phone with the Bank of America, and this is in reference to the monies that were supposedly inbound, and that's why she's talking with Bank of America.
I'm going to object on lack of personal knowledge.
All right, that's fair. Sustained.
As part of your investigation, did you download records indicating when the defendant was using her cell phone to make phone calls?
Yes.
Did you compare the text messagings with the downloads to see if, in fact, she was on the phone with the bank?
There were instances where she claimed to be on the phone and she wasn't, and there were instances where
Judge, I'm going to object. This is a broad.
I withdraw that. That's,
okay.
Thank you.
And a lie.
And a lie.
21. What's DFAS?
DFAS is the Defense Finance Accounting Service. It's a federal government entity that deals with defense finance.
My old job.
And 2 days before Michael collapsed, there's a reference to the organization you just mentioned. Who's Betsy?
Betsy was earlier referenced in testimony to Betsy Britland. Betsy was a character created by Natalie Cochran to be a government employee that she communicated with regarding government contracts on the regular. She would ask, or when asked about contracts, she had told Michael that her point of contact was Betsy Britland with DFAS or the U.S. Treasury.
That's not in the exhibit. The witness is testifying from some other unidentified documents. I object to it.
Overruled.
Go ahead.
So Betsy Britland, who did not exist, this is a reference to Natalie claiming to have spoken with Betsy regarding the contracts and the whereabouts of the award money that should be coming to the contracts. And this text is, again, to Michael Cochran.
22. And on 2-4 at 3:01. 2-4-19 at 3:01.
Again, this again is a text message from Natalie Cochran to Michael Cochran, assuring him that all 4 wire transfers and money deposits were en route and that they potentially could show up that day on February the 4th. And she references 4.8 regarding millions of dollars that should arrive in the morning and 23.8 million tomorrow, the next day at some time.
This looks really bad.
From your review of the text messages between the defendant and Michael Cochran, the defendant and Wendy Poteet, the defendant and the Davises, the defendant and Stephanie Hamilton, was there a pattern emerging there?
Yes, there was.
And was always deception to all of those parties, was it not?
Judge, now the prosecutor is testifying. I object.
Fair point.
Sustained.
The text messages that we've reviewed in summary fashion, did they indicate a pattern to you?
They did.
What is that pattern?
That Michael Cochran was being told the exact same information that the investors were being told. Those who were relying on money to be paid back to them, the information that was given to them is the exact information that was being given to Michael Cochran.
And that all derived from the defendant, correct?
Yes.
Could I have just a moment, please?
Sure.
How do you cross that?
There was also reference in the defense case to Michael utilizing the defendant's phone and sending messages as a guise that it was her sending them. Do you remember that?
Yes.
Oops, I need another marker.
This is State's Exhibit number 39, Your Honor.
All right.
Mr. Truman walks around the courtroom like he owns the place, posts up right next to the witness, wanders up to the front near the jury. Apparently the judge granted permission, and it's blanket permission. He can go where he wants to go. He's very confident. It's portraying a very high level of confidence in what he's presenting here.
And what's been marked for identification is State's 39. Ask you if you could identify that.
You want me to identify?
What?
Yes.
It's
This
more
is
than
a
free water.
photograph of a text message from the cell phone of Matt McCormick. It's a text message stream between Matt McCormick and Michael Cochran.
What time is the text message from Michael Cochran?
There are two dates here. Do you want
the second one?
On February 6th at 1:39 p.m., there is a text message that was sent from.
I'm going to object to this. This has nothing to do with my client's statement. This is hearsay.
We don't think so.
This is a statement between two third parties. One is dead, the
One's
other one is a
unavailable.
third party.
Care to
Unavailable
respond,
witness.
Mr. Truman?
Yes, sir. This is a text from Michael Cochran's phone when all the evidence says Michael Cochran was totally unconscious and lying on a couch.
I'll allow it. Overruled. Go ahead.
Oh.
This is a text message at 1:39 p.m. from Michael Cochran's phone to Matt McCormick's phone, in which he is telling Mr. McCormick that he would be available to see him in a few days, reference a firearms transaction.
From your investigation and from all the evidence to date, is there any possible way that Michael Cochran could have sent that text?
No, not at 1:39 p.m.
Why not?
We have a timestamped photograph taken by Natalie Cochran at approximately 12:30 of Michael Cochran laying on the floor at their residence. And then soon after, we have witness testimony of individuals at their house with him in his unresponsive state during that time frame.
That's bad.
Your Honor, at this point, the state moves into evidence. I can't remember the numbers. Is it 37, 8, and 9?
37, 38, and 39.
Please.
And I'll preserve the defense objections previously made. Are there further objections that you wish to place on the record?
Now, Your Honor, to all of which I do object.
All right. I'm going to admit States Exhibits 37, 38, and 39 over the defense objections.
Your Honor, the state has no further questions.
That
All right. Cross-examination, Mr. Victor.
Resting your case with a mic drop. Wow. I object to my objections.
Mr. Heinzman, the purpose of your testimony here today is to demonstrate that Michael Cochran, and this is an old story, was duped by my client, Natalie Cochran, and didn't know anything about these contracts, right?
Yes.
Now, and for that matter, the other message there that you are telling the jury about is that Natalie Cochran was involved in the illicit business of contracts. Is that right?
Yes, that's correct.
She's already been convicted for that.
Would you agree with me, sir, that throughout this trial, as you were sitting here, we have conceded that Natalie Cochran was a bad girl and she was dealing in those federal contracts? Did we concede it or not?
Did you concede to it? I don't know who we is.
Listen carefully. Is it true that Natalie Cochran has conceded that she was involved in the fraudulent scheme?
Yes, she
So
did.
that shouldn't be any surprise for you when you look at all these documents. That she is involved in these transactions.
The purpose of my testimony was to illustrate that Michael Cochran was not involved in the illicit transaction.
Michael Cochran wasn't involved in it. All right. I'm going to ask you if I can do this. Looking at one of the examples.
I believe Michael was involved, but somehow
I do not recall which.
How did he not know they didn't have contracts?
Number
They
it
weren't
was.
awarded.
I think it's somewhere around 5 or 6. But you testified about this document, didn't you?
Yes, I did.
That document was telling you
Can't see
that on August the 30th, and I presume 2018, $1.2 million was going to be posted, right? See it there?
On August 30th, yes.
Yeah. Posted in the account of Mr. and Mrs. Cochran, right?
Yes.
Then on September the 4th, I'm sorry, the 3rd, $724,000 was going to be posted. May not be the 3rd because it's going to be a holiday, but it was going to be posted in the Cochran's account, right?
Yes.
And then
I'd like to see the contract numbers on these and see if they were actually
$2.56
awarded
million
them or
next
posted them.
Friday was going to be posted in their account, right?
Yes.
Well, comes August 28th, no money in the account, right?
Correct.
Comes August 29th, no money in the account.
Correct.
Comes the end of September, no money in the account, right? Right?
Yes.
Yes. Well, come about that $2.6 million next Friday, so that's probably sometime, I don't know, sometime at the beginning of September, right? No $2.6 million coming.
Correct.
And Mr. Cochran doesn't know that? He is waiting for about $4 million, right? Right?
The last date put out on these is December, so between August 27th and December, it was over $300 million that he was
I
told
asked
was
you
due.
about these numbers. $300,000, $1.2 million, $724,000, $2.6 million. There's nothing about December there, is there?
December 21st on the next one down. 12/21. $131 million on 12/21.
I didn't ask you about that, sir.
Don't
I asked you
ignore
about
the other
top,
message.
Okay.
The exhibit. There's about $4 million coming to Michael Cochran, to his account, right?
To the business. Yes.
To the business where Michael Cochran is a minority owner, right?
No.
No? To the business where he has a joint account, right? Yes, sir? Yes or no?
Yes.
Yes. $4 million coming to my account, and I don't know anything about it?
That is correct.
And-
Well, he knows what's been told to him here
Okay.
about the
Well,
$4 million.
Fine. Then let me ask you this. We are now at the beginning of October. That $4 million didn't materialize itself. He is not asking questions, is he?
He absolutely is. The defendant had
is?
produced an audit
Show me in
ruse.
any of these documents, sir.
An audit ruse.
Show me any of these documents, these exhibits,
when he is
There should be
asking
an
any
objection from the
questions
state right there.
about where is that $4 million?
We have.
Where is that $4 million? Show me any of these documents here that were admitted into the evidence. Not some stuff about we did our investigation. Show me in any of these documents.
If you'll hand the documents back, I'll review them to see if I can find that.
You can review them all you want.
But I know that throughout the text messages that were reviewed, 1,224 pages of text messages are
I don't care about this.
numerous times that Mr. Cochran asked where the money was
Mr.
at.
Heinzman, there's no question pending. I'm asking you to show this jury from these documents that Michael doesn't know, that Michael somehow is not surprised that the $4 million that was supposed to come to him at the beginning of September is not there. Show me.
He had been told
Show the
it
jury.
wasn't coming because of an
No,
audit.
No, sir. You look at these documents, show me if there is anything in these documents that indicate that Michael Cochran is or is not surprised by not getting $4 million.
Your Honor, do you may take the time to review all these documents?
Well, if you can, go ahead, Mr. Heinzman.
I'll move quickly.
All right.
And I'm looking specifically for where is that $4 million that was supposed to come in September?
What? He wants to couch the answer knowing that the $4 million didn't arrive. Show me in here where it arrived. I can show you where she says we're under audit, so that all the funds have been held. Why is the state not jumping up and down saying objection? It's in this. It's on this page. He didn't provide a limited base set that doesn't include the data he's looking for. Who just burped? Somebody burped.
Would you restate your question?
Well, show me in any of these documents when Michael Cochran is asking Natalie, or anybody for that matter, where is that $4 million, or, well, 300,000, 3.4, well, there's more than that. 300,000, $1.2 million, $724,000, and $2.56 million. Where is it? It was supposed to be deposited. Now it's September, it's October, it's November. Where on earth is that money? Show me any of these documents indicating his inquiry about that.
Okay. On page 19, he's referencing the 1.6 million, having to wait for that. On page 20, when she says she's on the phone with Bank of America, he's asking, are we 1,000%? Because she's told him at that point that the money is at Bank of America.
Okay.
On page 21, he says, this is February 4th, the day that 3 days after he expected the money, he tells her that the money isn't there. She provides additional excuses for that. And then on page 22, dated February 4th again, she's telling him that the 88 million and 297 million will possibly show up today.
No, she's telling him
4.8 million in the morning and 23.8 tomorrow. Again, another delay, and his response is shit.
All right. Okay. Show me.
You want me to go through the rest of the documents?
Hold on. Show me when there's going to be $108 million to be deposited in the account on October the 12th.
It's right there on August 27th on the text that's being provided.
And $131 million to be deposited in November and in December.
Yes, it's right there on the text.
And he doesn't know that this money ain't there?
No, he does. He believes this money is coming. What's significant about August 27th?
No, I didn't ask you. Do Do you seriously?
I can explain.
Hold on, sir.
Okay.
Are you seriously contending before this jury that he doesn't know that that $239 million is not there?
I'm telling
Yes or
this
no,
jury
sir?
that
Yes
Michael
or no?
Cochran does not know.
Yes or
because
no,
he
Your
believes
Honor?
that money is coming.
Your Honor, I'm sorry. It's a yes or no.
Well, he's trying to explain, and I think we should let the witness explain his answer. Go ahead, Mr. Heinzman.
Thank you, Judge.
Michael Cochran
Statement
has
object.
been led to believe that all this money is coming to their accounts for government contracts, and it never comes.
And I presume that in September, October, November, and December, and January, he lives in the same household as Natalie Cochran, right?
He does, yes.
He certainly doesn't live on another planet. He can talk to Natalie Cochran about these contracts on a daily basis. He can talk to her, can he not?
Yeah, he does.
And he does. And he, on August 20, whenever, September, honey, where is that $8 million or $4 million? And she's lying to him, right? Is that your testimony?
And she says, we're getting hit with an audit. Can you believe it?
On September 5th, she's telling him, oh, no, that money is coming, right? On September 6th, 7th, 8th, 30th, October, he is somehow duped by it, and he's so blind to it that he will not ask his wife, where is $238 million? And he naively and blindly believes that this money is going to be there and it ain't there? Is that what you're testifying to, Detective?
Absolutely.
All right.
Absolutely.
Show me. There's nothing in these documents that talks about Michael's computer. Is there? Michael
not in these documents.
Arranging for these contracts on his computer as he's sitting in the bedroom while Natalie is watching TV and the kid is between them. Those documents don't deal with any computer operations of Michael Cochran, right?
No, they do not.
Okay. Those documents did not deal with any personal contacts that Michael Cochran had with the investors, including his own mother. Correct?
These documents do not.
These documents do not deal with any checks that he wrote, as we saw in some of the exhibits here, on behalf of the companies. Correct?
Correct.
For either services rendered or for consulting services, etc., right? These
Correct.
documents don't show that. These documents don't, these documents do not address any issues that, the detectives are coming and, maybe they should talk to the kids. Is there anything about that anywhere?
No, that wouldn't be anything like that.
All right. These documents, of course, do not deal, again, in the same old story, with the lifestyle of the Cochrans, right?
These documents do not.
Honey, I'm taking you to Paris and I'm going to get you a Louis Vuitton bag for God only knows how many thousands of dollars, because we have somebody else's money to live high on a hog, right? These documents don't deal with this, do they?
Not that depiction, no.
No, not that depiction. Well, they don't talk about any of the wealth that the Cochrans, plural, have acquired through the illegal schemes and enjoyed for a long time, right?
These documents do not.
These documents don't deal with anything about Michael Cochran's health. Honey, I feel bad today, I'm declining, or anything of that nature.
There are references to him being stressed because of the lack of money.
He is stressed because he doesn't know.
In these documents I'm referring to.
He's like in a National Enquirer. We want to know, right? He wants to know. right?
He wants to know where the money is that they've earned
wants to know.
through what he believed was legitimately awarded government contracts.
Right. And yet he goes to a boat sale and buys himself 2 boats at the same time, right?
I don't know if he went to a boat sale. I know that he did purchase ATVs, boats, vehicles,
right,
things of that nature that both he and his wife picked out based on text messages we read, or by her encouragement to make purchases because she had led him to believe that they had all this
she led him
wealth.
to believe. And you truly believe it.
Absolutely.
Right. All right. These documents do not show, these documents that deal with Natalie only, not Michael, whether he was copied on them. Do they?
Would you ask that again?
No, you look at any of these documents where Natalie is talking to Miss Petite or Chris Davis, where Mr. Cochran is not involved. Is there any indication that he is copied on those conversations?
Some of them, yes.
Yeah. So some of this he knows, right?
Some of it, but
Yeah.
not in this context that you're framing it.
Not in this context, of course. Okay. Now, when he talks on some of those messages, the jury will probably see that those conversations take place after Michael's death, right?
Yes.
So he cannot contract anything, Mr. Heinzman, because unfortunately he's passed away, right? Right?
Yes.
And Natalie Cochran is continuing the scheme that she was involved in, but it has nothing to do with what Michael knew and what he didn't know because he's dead. Right?
No, it supports the fact that it was her scheme because she continued it on.
It supports. Well, one of those exhibits, Michael asked, no, 16. Michael asked directly to pull out $9,500. From where?
From their personal account.
To do what with it?
To have some cash on hand.
And that $9,500 came from where? They didn't have any income, independent income. That must have come from the investors, right?
That or rescue loans.
Well, is it possible that since they have no income, independent income, you testified that Natalie wasn't working as a pharmacist anymore, and Michael's job was an IT man, not really defined, that he's pulling $9,500 in cash that must have come from the investors, right?
Yes.
So he pulls $9,500 that he considers money earned, right?
From previous contracts.
If
yes.
If he believes that, if he's so scrupulously honest, well, he must believe that this is the money that they've already earned on those contracts, right?
Right. He's not aware that they're illicit proceeds. He thinks they're legitimate proceeds.
Right.
Right.
What does $9,500 tell you as an investigator of money laundering?
It's under 10,000 because it's not
Well,
reportable.
That
cash. I'm going to ask 9,500 cash. What does that tell you? You're the expert here on money laundering.
Sure. In this context, it means nothing. In the context that you're framing it, it references currency transaction reports. Those are a federal requirement under the Bank Secrecy Act.
Well, let me ask you this. Let me ask you this. Well, I'll ask a very specific question.
The witness should be permitted to answer. Go
Explain
ahead,
that
Mr.
$10,000 cash.
The Bank Secrecy Act requires financial institutions to file what's called a currency transaction report for any transaction involving $10,000 of U.S. currency that'd be cash or coin in or out of a financial institution. It is a derivative of the Patriot Act and the War on Terrorism, so they want to track large amounts of cash. So if a withdrawal from a financial institution were to occur above $10,000, the bank would be required to complete a currency transaction report and document that transaction. In this case, however,
Well, I'm
the
sorry.
Cochrans
Now
had
let me-
cash
I'm
inside
sorry.
a
I'm
safe.
sorry, Your Honor.
Okay.
Now the question is this.
Fair enough. He's answered the question. Go ahead, Mr. Victor.
$9,500 in cash is obviously under 10 grand, right?
It is.
And he withdraws that amount of money in cash, right?
Yes.
Would you agree with me that he does that for the purpose to avoid the $10,000 money reporting necessity?
No, I would not.
No?
That's not illegal. It's not an illegal act. It's when that is anything 10,000 or more
Right.
is taken out in multiple increments over a short period of time. That would then trigger what's called a suspicious activity report
Right.
with the bank that ties back into the currency transaction report.
And
So
that's
that,
why-
that amount alone is not illegal.
And that's why he's taking $9,500 rather than 10,000, because he would have to report it to the IRS.
Your Honor, that's speculation. There's no way that the
Well,
witness could read the
Sustain.
defendant.
All right. That's fine. What about those income tax returns that the parties filed jointly?
Those were prepared by Natalie Cochran. They were false documents.
They were false documents.
Yes.
And he signed off on them.
There was no signature by Michael on the documents.
For 2017,
No, there was not.
2018,
No, there was not.
2019,
No, there was not.
and you're telling this court that she filed taxes and he didn't know anything about the income tax returns.
That's correct.
So he himself broke the law by not filing income tax.
If he had known what was being filed,
If he had known, he would have filed taxes.
no, if he had known what was being filed.
Okay. So he didn't have to sign the income tax return because his income was zero? Why didn't he have to file income tax return with Natalie?
I'm not saying he didn't have to,
Why didn't he sign those?
because they're done electronically now. You don't even have to sign them. One person could fill them out and file them electronically. He doesn't have to sign it. Now, the law requires that all tax preparers review their documents that they're filing, but
And he reviewed them, and he had absolutely no idea what Natalie was doing with the taxes, and with the bank losses, and with, well, the business losses, the business gains, etc., etc.
I have no idea if he reviewed them. If he had, he would further believe that he had made an extraordinary amount of money on government contracts.
Show me here any income tax return that lists about $4 million by the Cochrans. Can you do that? Can you show this jury?
No, I cannot. I don't have the discovery files and records with me to break out the tax returns that we did recover.
From your thorough investigation of this case, because you said that several times, was there ever an income tax return filed by the Cochrans that would list $239 million?
That's the business income.
Can
not
you
the
tell the
Cochrans.
jury that?
I know that there are tax documents that were given as ruses to get bank loans.
From your memory, Mr. Heinz.
But I cannot say if that figure that Mr. Victor has given me matches those documents.
$239 million, would that raise some red flags if you ever saw an income tax return from a small West Virginia company filed with the Internal Revenue Service? Would that cause you to pause and consider that?
No.
In what context?
Well, somebody's making $239 million from a business
That's not profit.
and files that income tax return. I would like to know the details of it.
Are you talking about the IRS would want to know the details, or?
Well, you were investigating their.
I've already answered that question. If I saw that, it's another prop. It's a ruse. It's not unsubstantiated by financial records, income records, state databases, federal databases. It would just, to me, if I saw that.
So you have
it would
no
be another
idea.
prop.
So you have no idea as you sit here today to tell this jury how much money Mr. and Mrs. Cochran were making and how much money they were reporting. True? As you sit here right now. Can you or can you not?
It's a very broad question.
Well, how much money did they make in 2018? Can you tell this jury whether they made millions or whether they made a couple of $1,000s here and there?
2018?
Yeah.
Are we talking about legal income or illegal income?
Income tax return. You remember?
The income tax returns that we reviewed were submitted not to the IRS because that would have got red flags, but to people that they wanted to borrow money for to demonstrate the value of the company.
So now you're telling us that Natalie didn't file income tax in 2018?
My recollection was that there had not been income taxes. No, let me correct that. The income tax documents that we recovered had been doctored to show greater income because they were used for other purposes. The actual income tax that was filed, which was presumably would have been legitimate, we did not review.
I see. Now,
yeah, that's bad.
now, okay, if I may have a second.
Take your time.
I don't think I have any more questions of this witness.
All right, redirect Mr. Truman.
That's from the state, Your Honor. Thank you.
And we're done.
Mr. Huntsman, you may step down, sir.
Thank you, Your Honor. Copies or exhibits?
I think we've got the exhibits spread all around. Let's make sure that we collect them. Give everything to the clerk and she can sort them.
38. Okay. We've got them, Your Honor.
Okay.
Okay, the question is, has the state proved the defendant is guilty of murder? Poll is up.
It's part of it. Fell off.
Part of it.
It fell off.
If it's a copy, no, I don't need it.
This fell off of here. That's part of 38.
Let me inquire, Mr. Truman, will there be further witnesses in rebuttal?
Your Honor, the state rests.
We're done.
All right, will the defense have any rebuttal evidence? Certainly.
Hang on. They're gonna let them go again? Do you want to testify, ma'am? Do you want to change your mind again? That would be a bombshell. Could she? Would she?
The defense rests like
They
that.
rest.
All right, members of the jury, you've heard
Wow.
it from the lawyers themselves. This is the completion of all the evidence to be presented before you. The next phase of the case will be the instructions of the law by the court. I will read the instructions to you. That's one thing that we have been working on to try to get a leg up and get ahead of the game, so to speak. We've pretty much settled on the instructions, and so we should be ready to go this afternoon. We've worked into the traditional lunch hour, and so be back in your jury room at 1:30. That'll give you a little extra time for lunch. We will commence hopefully with instructions at that time. and argument of counsel thereafter. So although we are winding down, and although we have completed the presentation of the evidence before you, the case is not over. It would be improper for you to discuss the case among yourselves or with anyone else at this time. Please enjoy your lunch. Do not do any research. Do not read anything online in the newspaper or on TV. And be back, please, in your jury room a little bit before 1:30. You may go with the bailiff now to your jury room.
We didn't hear what the treats were this morning. The judge did not say. Kim, you're quick. After lunch, we will have closing arguments in this case.
All right, Mr. Truman, I'm hopeful that you can have a working lunch and maybe go through the charge while you eat your sandwich.
I'll take care of, yes. I'm on page 8.
Okay.
I have them done.
All right, thank you.
So far, there's only been a couple little things to check on.
All right. Maybe we can come back at 1:15, so we'll have 15 minutes to make any corrections.
I think that should do it.
All right, and then we can start out on time. I don't want to delay the jury anymore if we can help it. Is there anything further on behalf of the defense that we need to discuss?
No, Your Honor. Thank you.
All right, we'll break for lunch, and if you can, be back at 1:15 so we can take up the instructions further.
All right, that means we just get a 45-minute lunch. Hey, it's the vent and the flag. We get a 45-minute lunch. This is crazy. We've got a poll going up right now. Just one second. Let me pull that one up. See where we're at. Has the state proved the defendant is guilty of murder? I worded it that way intentionally. Not what do you think, is she guilty or not, but we wanted, is it proved? Currently, we're sitting just about at 70% on a guilty, 70% on guilty, 30% on not guilty. That's barely over 2/3 think she's guilty or feel that they've proven this. We're going to take our lunch break. When we come back, we're going to have the closing arguments, which are going to be spicy as well. Let me get the redirect added. It looks like Kim's already first in chat on the redirect. Congratulations, Kim. That was quick. What say me? I would say the state has done enough to prove that she's guilty of the Ponzi scheme, again, which she's already been convicted of. And the state has done enough to prove that she is a very bad girl. If it weren't for the fact that he was, all the testimony, which I found believable, that he was into bodybuilding, that he was taking a whole bunch of meds, possibly some from other countries, taking a bunch of pills. My knowledge of the medical world is limited. And we had a lot of testimony on that, and a lot of you guys understand better than I do. But for me, I'm like, that still raises a possibility that something bad happened. Now, this last bit we heard, man, that makes the timing of his death pretty significant. All right, when he's like, look, where's the money? And then he dies. Sure goes to motive. I've got to think it over. I don't think we got any proof of anything out of Mexico. Could all be just her saying it. But the kid said it as well, which could have come from her as well. That was not disputed. This was a trial for financial crime. It feels like the Murdaugh case in a lot of ways, where we spent so much time focusing on other stuff, which goes to motive. See, Red Pen, what's your question? Let's see. Why is Greener's listing all his favorite states? Alaska, Arizona, Arkansas, California, Colorado, Idaho, Illinois, Indiana, Kentucky, Louisiana, Michigan, Montana, Nevada, Ohio, Oklahoma, Oregon, Texas, Utah, Washington, and Wyoming. What is that? Kids were coached. All her words are useless. It was in reference to FDA raises alert on broccoli sold at Walmart over risk of death. Hang on. You know, kids are going to cite this forever. This is like a story for the podcast. Mom, I don't want to eat my broccoli. It could kill me. Broccoli recall. I like broccoli. Listeria. Crazy. No, Remy. That's a rough one. Broccoli can kill you. All right. Are Brussels sprouts still good? Asking for a friend. We're going to go to lunch because the state is rested, defense rested, the state provided rebuttal, then rested again. Defense does not have any response to that. There were some spicy arguments. We got up to, what was it, 130 objections, which is 5 more than I guessed we were going to end at. When we come back, we have jury instructions and closing arguments. This will all go to the jury. They can decide if this was proven or not. It is entirely circumstantial. And I say still, it's an uphill battle. They have proven motive. They have proven motive in a heartbeat. But I'm not convinced yet. I'm a holdout. And this is weird because I was on the side that said that Zachariah Anderson was guilty. For me, that one speck of DNA in his van where it should not have been was enough to get me past that hurdle. But here I'm saying I don't see it. I don't see it yet. So we'll see. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again. We'll be back at 1 o'clock, so about 40 minutes to have a quick lunch. And we'll be here for closing arguments. If you would like, we're going to do a portal right over to the new one, so you don't have to go anywhere. Let me make sure it's set up here, and it is. So we're gonna portal right over to the new thumbnail, and we'll be talking this over. We'll be live in about 40 minutes. You guys have a good lunch. See you later.